Hello, one. Hello, one.
And don't forget to use the hashtag CILE2023. Live stream is also available, offering you the full coverage of the conference. You will be able at any time to interact, ask questions, connect with the conference using the hashtag CILE2023 on Twitter. Moving forward, it's now my great pleasure to introduce the speakers of the opening remarks. Dr. Ibrahim Zain is the Executive Associate Dean and the Professor of Islamic Studies and Comparative Religion at the College of Islamic Studies, Hamad bin Khalifa University. Dr. Muhammad Ghali is the Acting Director and the Professor of Islamic and Biomedical Ethics at the Research Center for Islamic Legislation and Ethics at Hamad bin Khalifa University. Dr. Samir Rashwani is a scholar of Quranic Studies and Scriptural Ethics at the Research Center for Islamic Legislation and Ethics at Hamad bin Khalifa University in Qatar. Please join me in welcoming the speakers.
بسم الله الرحمن الرحيم الحمد لله والصلاة والسلام على أشرف خلق الله سيدنا محمد وعلى آله وصحبه ومن والاه. My dear colleague Muhammad Ghali and professors in CILE and the foreign participants, Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Well, on behalf of the Dean of the College of Islamic Studies, Dr. Rajab Shantok, I would like to welcome you all to the 10th annual conference, CILE 10th annual conference. I mean, these are 10 solid years of knowledge production. And I should say at the beginning that CILE now is a leading center in applied Islamic ethics through their publications, the Journal of Islamic Studies, as well as the edited volumes that have been coming out every year from the professors of CILE. Doing this perhaps, or certainly, is developing a new interdisciplinary discipline, if that's if that is making sense to you. I mean, following CILE, this is what I could say about the things that they have been developing throughout the years. It's about Islamic ethics, but at the same time, Islamic ethics cannot be a monopoly of one discipline. Islamic ethics will bring in people from biomedical ethics, people from political ethics, scriptural ethics, and some other issues connected to ethics. And most important of all, they are focusing on this applied aspect of Islamic ethics, meaning actually the relevancy of Islamic ethics to the day-to-day activities of the Muslims and others. Now, I and my colleagues in the College of Islamic Studies, we are very proud of CILE. And we feel that CILE is contributing to human knowledge through their work and through their achievements and through their also outreach programs. They have quite a number of outreach programs that are well known internationally. I'm not going to take that much from your time. It's just to welcome you, especially the foreign participants. And I think Doha is a beautiful place to be, especially after the World Cup. The city has been completely transformed into a modern and beautiful city. Please, I mean, after the conference or during the conference, feel free, I guess, to go and visit different places which are deserve to be visited by whoever is coming to this beautiful country. With this, I thank you all and I wish you a very productive 2 days conference. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Assalamu alaikum wa rahmatullahi wa barakatuh. Thank you, Dr. Ibrahim. And thanks for our guests for being with us here today, and for Dr. Samer and CILE team, admin, faculty, and everyone who was behind this. Great work they have been doing. I'll just say a few words about our work in CILE. This is the acronym, CILE. This is how we pronounce it. I know that some would call it CILE or CILE or something like that. We usually say it CILE. This is the famous mistake, if you may say, the Research Center for Islamic Legislation and Ethics. We are a research center which makes part of the College of Islamic Studies. And our main specialization is ethics in the Islamic tradition. The core part of our work is research. Besides the usual and conventional research activities done and conducted by the CILE faculty, writing articles, publishing books, etc., we also work with others. We know that we cannot work on a broad and emerging and promising field like Islamic ethics. We cannot do this alone. So collaborating with researchers, scholars, and students from around the world and from different disciplines is a necessity. So we have, for instance, every year a number of activities. One of them is the international conference, like the one we have today. We also have research seminars. In these research seminars, they are usually preceded by call for papers, accompanied by a background paper where interested researchers can apply their papers, and then we have a review committee within the research center to choose the papers, and then we come together for 2 or 3 days to discuss the papers, and after this we have the publication. In the international conference, we choose the people who have a strong research record in their specialization, like what we have today, human rights and its interplay with Islamic ethics, and also we plan the publishing the outcome of these activities, whether the seminars or the international conferences. Usually our publications go to one of the 2 publication arms of the research center. We have the Journal of Islamic Ethics, and this is a Scopus indexed Q1 journal. And we publish there Arabic and English articles. And then we have the book series, series Studies in Islamic Ethics. Both are published by Brill, and in both podiums we publish both in Arabic and in English. And then we have research projects we are working on at the moment. So we are, for instance, working on the Routledge Handbook of Islamic Ethics. We will host the World Congress of Bioethics next year, which will be the first time to have such a large-scale event in the field in the Arab world and the whole Middle East. So we are very happy to have this. Of course, it's a heavy burden on us, the whole team, but we are working happily towards this event as well. Besides the research, we are also engaged in teaching. In the College of Islamic Studies, we have the MA program, Applied Islamic Ethics. And CILE faculty are teaching in this program. And it's a 2-year program available for local and international students. To the best of our knowledge, the only MA program in this field. We also have organized a summer and winter school every year available for students all over the world. Most of the time, especially during the COVID pandemic, we had them online, but sometimes we do this also face-to-face, summer and winter school. We also used to have, good to have Dr. Ibrahim with us, a visiting research program. This was stopped because of the pandemic. We hope that it will be reactivated again, where we can receive researchers working in conducting research in the field, like organizing a seminar and stuff like this, working on a publication, and also teaching in the program. We hope that this will happen soon. And in the outreach, we try to use the research and the activities in the teaching to be of help for the society. So we are in close collaboration with different ministries and governmental bodies here in Qatar, the region, and elsewhere in the world. So Ministry of Labor, Ministry of Health, different ministries. We provide consultancies for them. We draft national policies for their work, the last of which was the national policy for genomic research. We work with international organizations like World Health Organization, WHO. We provide also consultancies for them, different institutions around the world. Also the branch campuses here in the education city. We work very closely with them. We deliver lectures and stuff like this for high school students and so on, so that our research will be accessible to a wider range of audience. This is more or less what we have been doing in our research center. Again, I stress that this cannot be done only by the small team of professors and people working at CILE. We always need support and collaboration with people like you. So we welcome collaboration with the individual researchers, with their institutions, to work, for instance, on developing an idea for a research seminar, or collaboration with organizing some events like our international conference, a summer school and winter school. We will always be very happy to do that. This is what I had to say. Thank you very much, and I give the word to Dr. Sam. Thank you.
Assalamu alaikum. Good morning, everyone. First of all, I would like to thank, to express my deepest gratitude to all participants for their acceptance to be part of this event, and for their effort and time they invested in this. I understand I approached many academics who apparently this time of year is not preferable for many of them. So I thank you very much for that. Also, I want to thank our admin team, the Mawahid, Muna, Amina, and our research assistant Sarah for their great effort to make this happen. In this short introduction, I would like to talk a little bit and explain the stimulus behind this conference, its rationale, and the aim or the purpose and ambition of this event. So the idea. Sorry. Okay. So shall I repeat, or is it okay? Okay, I will go ahead. So, in this short introduction, I'm going to explain the stimulus behind this conference, its rationale and ambition. So the idea of studying the intersection between human rights and ethics in general and Islamic ethics in specific was triggered by several observations. The first one is related to how the language of rights occupied the whole spectrum of moral and legal language. Human rights are used in many circumstances to replace ethics and are taken for granted in a way that somehow constitute another way of doing ethics. Such an approach was criticized by many philosophers and intellectuals, such as Michael Sandels, Charles Taylor, and Amartya Sen, etc., because it not only undermines but also operates against a range of other morally significant human relationships and attitudes. These include community, solidarity, care, compassion, benevolence, all of which play an essential role in our lives, according to them. The second observation has to do with how human rights evolved into a field of study with an interdisciplinary framework. integrating insights from disciplines such as philosophy, politics, education, psychology, bioethics. So the interplay between these disciplines and human rights, understood as moral framework, is becoming a thriving field of research. The third observation has to do with the increasingly common understanding that professional ethical codes should be based on human rights as their main foundation, not as one of their elements. So one such example is the relationship between human rights and business ethics. So many companies have adopted policies that outline their commitment to respecting human rights of their employees, suppliers, customers, etc. This relationship is governed by international standards such as the United Nations Guiding Principles on Business and Human Rights, which provide guidance on how to align business operations with human rights. So this is only one example, but we see this in many other areas, such as bioethics, education, criminal justice, etc. The last observation has to do with how modern Islamic discourse developed around the idea of human rights. So modern Islamic discourse was by and large occupied by questions of identity, compatibility of Islamic law and human rights, or exploring the roots of human rights in scriptural sources. So these are the main observations. This conference is not primarily concerned with the worn-out questions about relationship, compatibility, or reconciliation between conventional international human rights and Islamic law. Attention will be instead turned to fresh and profound discussions about the interplay between Islamic ethics and social, economic, political rights. So case studies will focus on the rights of refugees, survivors of mass atrocities, including their psychological and mental health, as well as bioethics and related concepts such as human dignity, respect of human and personal integrity. Of course, for apparent reasons, this convention doesn't exhaust all issues, questions, or cases raised by the new vistas of human rights. However, the contributions in this conference cover roughly speaking, 4 areas of research. First of all, we have theoretical discussions about the concepts of universality, public morality, pluralism in human rights discourses. The second area is the idea of rights in Islamic tradition, how it was developed and discussed. Third, the social rights of women and religious communities. The fourth area is bioethics, medical and bioethics. The last topic has to do with political and constitutional rights and rights of refugees, migrants, and victims. In this context, I want to mention that some participants were unable to join us because of, for emergency reasons, such as Dr. Zainab Jallad, who wanted to talk about victims and survivors and international accountability. Hopefully, she will be part of the prospective plan of publication. At the end, I hope this event will spark fruitful and rich discussions that contribute to the current debate, both in academia and international institutions. Thank you very much, and looking forward to hearing you.
Thank you very much. And now we move to the first session of the conference, moderated by Dr. Mustafa Al-Amin. Dr. Mustafa Al-Amin is a professor of Islamic and Global Affairs at the College of Islamic Studies. He will be introducing the speakers of the first session, inshallah. Dr. Please allow me to welcome Dr. Mustafa Al-Amin to the stage.
بسم الله الرحمن الرحيم وبه نستعين. At the outset, let me thanks and coordinate. What's the problem? At the outset, let me thanks and shall we call them? I thought I will introduce them and then call them. How are you? Good to see you. Assalamu alaikum. بسم الله الرحمن الرحيم وبه نستعين. At the outset, let me thanks and congratulate CILE for the organizing the 10th annual international conference about Islamic ethics and human rights. And I would like also to welcome you all for the second session, the first session, and the two speakers which I'm going to introduce them. The first one is going to be Dr. Mashood Abrin, famous Nigerian, is now a professor in London School of Law, very expert in the field of human rights and international law, well-known diplomats and special envoy of the UN in different crises. At least one of them is in Sudan. And he has many publications and about human rights and the ethics also. He was specialized in, by the way, he is a very excellent Arabic speaker. And he got many degrees with excellent in Islamic studies and in Arabic language. The second one, of course, is well known to you, Dr. Mu'taz, who is one of the main pillars of CILE. And maybe when I will come to him, then I will introduce him. So our first speaker is going to be Professor Mashood. And Professor Mashood, you will have about 25 minutes to deliver your speech. So let me, with all of you, welcome the two speakers. Thank you.
Bismillah ar-Rahman ar-Rahim. Let me start by thanking Dr. Mustafa El-Amin for that very kind introduction. And I also want to thank CILE for inviting me to this very important meeting, very important conference. I hope that, inshallah, I should be able to make, I'm sorry about this. Okay, sorry about that, please. I hope I'm able to make a contribution. The title of my paper and the abstract which I submitted is Universal Human Rights versus Public Moral Clauses, an Islamic Ethical Legal Perspective. Now, this is something I've been working on for some time, and I thought perhaps maybe I will share my ideas here so that maybe it can improve my perceptions of the issues. I teach a course at SOAS, my university. It's a postgraduate course, Human Rights and Islamic Law. We have students from all over the world who take the course. And a lot of the time, we start by wanting to look at how Islamic law or Islamic ethics can contribute to international human rights law and also issues of compatibility. But at the end of the day, over the years, I've been teaching the course for about 12 years now. It's a new course. All the time, it boils down not to the fact that human rights, it's not about whether human rights is recognized within Islamic law or not. The main question usually relates to the limitations, the limitation clauses, how these are interpreted. Because a lot of the time we presume, especially lawyers, even though we know, we tend to promote human rights as absolute. That is, they are absolute. A lot of the time, when we talk about human rights, we talk of them from absolute perspectives. But in fact, as we know, many of the most important aspects of human rights are non-absolute. The state has capacity to limit them in certain situations, even though lawyers don't want to talk about that. But they are very, very important. It is at those levels, because if you look at the reports of many Muslim majority countries, it is these limitation clauses that actually they refer to a lot of the time. It's not about whether freedom of expression is recognized within Islamic law. It's not about whether freedom of religion, but it's about, the scope of the limitations. So it's really very, very important that we do address them. And ethics come in here, because one of the limitation clauses is about public morals. You can't limit many big human rights: freedom of expression, freedom of religion, right to privacy, family life. The state has power to limit them based entirely on public morals. And it's important now, and this is why I think this conference is important, because, of recent, there have been, a lot of more calls to form some sort of, global morality or ethics that is shared by all faiths, cultures, and civilizations to address, many of the problems that confronts the world now, including issues of human rights. Yet, it's not easy. It's a very difficult task to be able to, as you will see in relation to how these public moral clauses are interpreted. It's a very, very difficult task. And it has raised so many questions that have agitated, great minds over time. For example, we're talking about ethics, morality, public morals clauses. What do we mean by morals? What do we mean by ethics? Is there or can there be a global basis, for example, of morality? How do you know, or how do we know what is correct ethics or correct morals? How do we know? Should it be based on rational judgment? We have the concept of rational ethics, or based on divine injunctions, religious ethics, for example, or should it be a mix of both? And the other thing is, unlike law, there's the debate: can ethics really be enforced? Can we really enforce it? Or perhaps, is it just a proposition to encourage people to do what is good? All these are important, questions which I hope perhaps maybe my presentation will have a look at. Now, what we know through empirical observation is that there are some actions that may be morally right, that some actions that may be morally right in one society may be morally wrong in another. And often it is said that the only moral standards against which a society's practice can be judged are its own. Yet, there are some moral standards that can be applied to all peoples in all societies all the times. So you find out that, it raises, different, issues. Now, based on its history, because we are looking at the intersection between human rights and Islamic ethics, but based on its history, it can be safely argued that the idea of human rights itself was actually motivated by the aspiration for some form of global morality or ethics that is protected and enforced by law. It's ethics, but as I said, ethics sometimes, it's all over the place. Who enforces it? So human rights itself it's an ethical or moral idea, but protected by law and enforced by it. Therefore, human rights, morals, and ethics, and I'll be using morals and ethics, interchangeably. My perception is that, ethics emerge from morals, moral values. So human rights, morals, and ethics, they are naturally interrelated. Morals inform ethics, and they both underpin the concept of human rights. As I said, although today human rights are promoted through a top-down, and that's it, that's where lawyers want to look. A lot of the time, a top-down, state-centric perception of human rights. And my argument is that a lot of the time, it is too late before that intervention. It is only after human rights have been violated that is where law kicks in. So it's top-down, you know. There's also the bottom-up, whereby if people are ethical enough, there will be no violations. The violations will be limited in relation to, you know, so this is where ethics come. And my argument is, when we talk about interrelationship between ethics, Islamic ethics, it's especially from the bottom-up perspective, whereby people will do things voluntarily. They will not actually not want to violate human rights. For example, a person who touches, a police officer who touches, perhaps if he has good ethical values, good Islamic ethical values, he won't do that anyway. It's a bottom-up approach. So it's really important that we do appreciate that, both are essential rather than looking at human rights strictly from a top-down approach. Now, the concept of, ethics forming the underpinning of human rights is usually reflected in most of international human rights, instruments, particularly in relation to the concept of, human dignity. And we find this, very well laid out in the Universal Declaration of Human Rights, which then extends to other treaties, whereas recognition of the inherent dignity and equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. And in its Article 1, it talks about the fact that all human beings are born free and equal in dignity and rights. Therefore, one strong argument, from an ethical point of view, is that no, human rights actually are not created by states. They are inherent. Ethically, they are inherent. You know, and this, from an Islamic perspective, Muslims believe that, well, when God created man, inherently he put some dignity in him. So it's there even before the state. So for that reason, we need to really, protect that. And the concept of human dignity is very well established, even from an Islamic point of view. You know, Quran chapter 17:70 is the initial basis. Well, we have really honored the children of Adam, that is human beings generally. It's not really based simply on religion, you know. And this is what I say, it's universal in the sense that the Quran didn't say, وَلَقَدْ كَرَّمْنَا الْمُسْلِمِينَ. That didn't say that we have honored the Muslims. We have honored humankind generally. And every human being has dignity. So that dignity is quite important in the sense that, you know, human rights is based on the concept of dignity, and Islamic law does, share that. But, you know, paradoxically, as I did say earlier, human rights is still also limited by this ethics, you know, of wanting to protect public morals. And therefore, sometimes it's like a paradox. If the basis of human rights is ethics, can it still then be limited by public morals, by ethics again? So it seems paradoxical. But perhaps one way of looking at it is to show that actually ethics or morals, you know, works both from a negative and positive perspective in order to strengthen, the human rights perspective. I wouldn't go too much in the, positive aspect in saying that, well, Islamic ethics can actually help from the basis of the human dignity to promote human rights. The element that I'll be talking about much is this concept of, public morals. How do we interpret this concept of, public morals in that regard to limit human rights? Now, in my paper, I have, listed in almost all instruments, right from the Universal Declaration of Human Rights. Actually, the provision of the Universal Declaration of Human Rights is a general limitation. It indicates that all the rights in the Universal Declaration may be limited. You know, it's general. It's not only, it covers all the rights. So you find out that, it's really very, very powerful in that regard. Then you have other instruments, even including the Arab Charter, even the OIC declaration, you find those limitations. And the areas where public morals come in, for example, right to liberty and freedom to choose, freedom of movement generally, then even public hearing, due process, right to fair trial. For public morals, sometimes the public or the press can be excluded, from hearings. To show how powerful this is. Then freedom of religion, manifestation of religion can be limited based on public morals. Even freedom of expression, peaceful assembly, and also, freedom of association. The Arab Charter uniquely also limits actually the freedom to pursue political activity. To pursue political can be limited by public morals. And our privacy and public life. And even trade, the Arab Charter, again, trade union rights can be limited by public morals. Now, if you look at it from that point of view, incidentally, all these specific rights that I've mentioned are mostly in the areas where there have been challenges in relation to the application of Islamic law and ethics in Muslim majority states with regard to their international human rights obligations. So it's really very, very important. Now, how has these limitations been interpreted? And that is where the question is. Now, if you look at, I'll give us example, for example, from the practices of the Human Rights Committee, that is the UN universal level, and also look at regional institutions, particularly the European Court of Human Rights. Now, the African Commission, the African Court also has jurisprudence in that regard, in ways that perhaps, indicates that there could be, differences in relation to how this has been interpreted. Now, first, starting with the, Human Rights Committee, if you look at the jurisprudence of the Human Rights Committee, interestingly, initially, at the initial stage, the Human Rights Committee had adopted what I call a particularistic interpretation of the public morality clauses, even though it indicates that it reserves for itself an assessment of whether in a particular given situation, whether the state has not gone beyond the limits of limiting, a particular right based on public morals. So it first gives itself that. Now, in one of the very, first cases, which is very well known, the Hesberg versus Finland case. And most of the cases actually are in relation to a very important, topic, which is really very rampant now, gay rights, LGBT, rights. Now, in the Hesberg and Finland case, the case concerned, Finland had restricted, speech concerning homosexuality. Based on, there was the Finnish penal code that limited, speech in relation to homosexuality. And Finland argued that they were doing it to promote, to protect, public morals. Now, the Human Rights Committee then had adopted a particularistic interpretation of the public morals, which perhaps maybe if it has stuck to that would not have been a problem even in relation to Muslim majority countries. It indicated that, well, the Finnish government, could do that based on its understanding of the public morals, of the state. Now, you find the Human Rights Committee argued, I will quote this, it has to be noted, first, that public morals differ widely. They argued that, well, you cannot have, say, public morals differ widely. There is no universally applicable common standard. Consequently, in this respect, a certain margin of discretion must be accorded to the responsible national authorities, which is Finland. So they found out that, Finland was, had done what was, right in that regard, Now, they relied on actually an international principle, the CILE principles on the limitation and derogation provisions in International Covenant on Civil and Political Rights, which was drafted by 31 experts, Western, including, people from different countries. And the CILE principles indicated that, yes, public morals are not universal, that they could be different from different places. So they relied on that to say that, look, a particularistic approach should be adopted. But you find out that, I mean, a few years after, in 1994, the Human Rights Committee departed from that perspective in the popular tuning case against Australia, which was also a case related to gay rights, homosexuality in that regard. And Australia was arguing that, they were criminalizing homosexuality on grounds of protecting public morals. In that regard, as perhaps, I mean, they believe the civil and political rights, treaty allowed. The Human Rights Committee stated it cannot. It departed completely from its earlier decision in relation to Finland. It said that it cannot accept the argument that public moral issues are exclusively within the domain of member states. So they argue strongly that, well, the committee has power to scrutinize, that there's a big burden of proof on states to be able to really establish that it was necessary to criminalize, homosexual and they then practices. And they then went on to argue that, well, because it's related to Tasmania in Australia, they indicated that, well, it's only Tasmania that has a criminal provision on homosexuality. And even in Tasmania, other countries in Australia, other parts of Australia didn't have this. And even in Tasmania, that it was difficult to say that this cuts across, that morals does not cut across the whole of Tasmania. There were people who didn't see anything wrong with homosexuality. There were people who saw something wrong with it. So to have a law that criminalizes it, on grounds of public morals cannot be justified, because public morals should be sort of universal publicly. So you find out that, since then, the Human Rights Committee has changed its position. It has adopted what I call a universalistic perspective that, well, for public morals to apply, the morals that the state is arguing must cut across. Everybody must accept it in relation to that perspective. Now, the European Court, for example, right from the beginning, as early as 1976, we know the handy side case against United Kingdom. It also related to issues that related to sexual acts. They published a book which was considered to be it's a book for children, really, whereby it encouraged children. It referred to sex and use of sex and drugs. So the UK seized the books and destroyed them, and therefore, the UK was brought before the European Court. Now, the European Court indicated then right from the beginning, because it adopted a particularistic perspective, indicate it is not possible to find in the domestic law of various contracting states a uniform European conception of morals. Says it's very difficult to find a uniform conception, so they leave it to the states because there's no uniform conception of morals. So each country, particularly, if they are able to establish that it was necessary for them to protect the morals of the state, of the country, then the European Court will give them what they call a margin of appreciation. It depends on, and they will test it based on what they call European consensus. If there is a legislative consensus, for example, across Europe, if there is political consensus and judicial consensus, they will not grant the margin of appreciation. But in situations where there are no consensus, so you find out that the two standards, and the European Court have followed this all through. After the handicide case, they have more than 700 cases. They have decided based on, the margin of appreciation and indicating that public morals should be left to the states. Now, you find, now perspective. My perception is that, both law and ethics are derived from the two primary sources of Islam, that is the Quran and the Sunnah, which for Muslims are divine sources. And therefore, because they are divine sources, the perception is that it limits the extent of their human rationalization. It limits the rationalization of those provisions. Now, while the legal injunctions in these sources are applicable as state law, the moral and the ethical injunctions in both sources are mostly exhortatory. They are recommendatory. And therefore, the question is, how far can the state go in enforcing them? It's debatable in relation to how far the state can go in there. Now, for example, you find that, in the Quran chapter 4, verse 86, even greetings, the Quran says that, when you are greeted, a greeting, you have to return the greeting, or even in a better way, at least or return it similarly, because God takes account of everything. Now, this is ethical, that when people greet you, greet back. But it will be debatable. Would the state want to enforce that? Would the state want to go and say that, well, we want to enforce anybody who does not return greeting, which is ethical, have committed. And so you find out that will be very debatable. Similarly, the issue of freedom of expression. If you look in the Quran as well, it talks about the issue of ridicule. It talks about the fact that Muslims, male and female, should not ridicule one another. Because the person you are ridiculing may be better than you in the face of. Now, if you look at those verses, they could ethically improve human relations. But the argument is, how many states will really want to go on to enforce that from a top-down perspective? It can only work by encouraging people to do that. For example, one example I give my students, and I'm a Muslim, yes, the Quran says this, I believe in it, but maybe I woke up this morning, I had a very bad dream, and I just came out, and my neighbor says, Salam alaikum. I decided to ignore him. I didn't answer. What can he do about it? At most he will say that, well, this person is not a good Muslim. The state may not really be able to enforce that. Except, of course, we push it really strongly from the bottom up, whereby people feel that, well, it's important for them to be able to do this. Therefore, Kamali, for example, Hashim Kamali, in his freedom of expression, has noted that being a religious law, the Sharia, is emphatic about moral and religious values, which, when we bring it to the platform of human rights, might mean imposing restrictions, which perhaps maybe from the Western perspective may be seen as personal matters, which fall outside the concerns of law, So, ethics are quite important, but the point is that they have to be really pursued from the bottom up, rather than expecting that, well, states it will be very, very controversial in relation to, it's different. For example, you find in the Quran verses on inheritance, that is, properties left by parents. Every child has a right to it. This is a legal verse. So, for example, if my brother wants to deny me of inheritance from my father, I can challenge it. I can go to court. The state can help me to challenge it. But greetings, the state, even if you bring it to a Sharia court, they will throw it out. It's an issue of morals and ethics, which must be pushed from the bottom up by, training people. Nevertheless, it must be acknowledged that, the legal injunctions, most of the legal injunctions, in fact, in the Quran, have ethical justifications. And this is also where, promoting an ethical perspective of Islamic law can help. Now, for example, if you look at the prohibition of zina, it's legally prohibited. And this comes to rationalization. A lot of the time, we might need to rationalize. If we want to bring ethics, Islamic ethics, into the platform of human rights, we might need to do some rationalization for it to be acceptable, not only based on divine, injunctions. Now, for example, if you look at zina is prohibited. The Quran says, La taqrabu zina, because it is fahishatan wa sa'a sabila. It is rationalized. God didn't just say, don't go to zina. God rationalized it because, so rationalization come. If you want to bring this in the public realm, you cannot just, because it's prohibited. You might need to be able to engage, indicating that the reason why it's prohibited, the Quran itself says that it is an evil, and you go to rationalize it. If you do that, then perhaps maybe it becomes much more acceptable. Now look at, and also one could, even the Sunnah, look at the man who came to the Prophet and said, let me commit zina. The Prophet said, people were really angry. The Prophet said, leave him. And the Prophet sat him down and asked him, would you like it to be committed against your mother? Would you like it to be committed against your daughter? The Prophet was rationalizing it to him. He said, no, I don't want it against my mother. No, I don't want it against And the Prophet said, everyone will not want it committed against their mother, So it was rationalization, in order to make it acceptable in that regard. So the point I'm making is, sometimes you might need to, the ethics, in order to be able to really push it, Islamic ethics, to be able to push it to work within Islamic, within human rights realms, there might be need for some sort of, rationalizing, making it rationalized. And the other part I want to talk about is, this is substantive. In procedural law, my argument actually is, in relation to the application of Islamic law and even ethics, many of the principles like maslaha, darura, necessity, human benefit, even maqasid, that is being promoted so much today, the issue of takhayyur and things like that, my argument that they are ethical principles. They are based on ethical principles, because when you say darura, that the law, you can leave the law aside in cases of difficulty, in cases of necessity. It's an ethical norm. That, well, it is only ethical that when the person is in difficulty, you give them some free will. So you find that even the procedures of substantive justice, are underlined by, moral ethics. And therefore, it's quite important that sometimes we might need to really move a little bit, trying to rationalize those ethics rather than just leaving them purely, if you want to bring it on the human rights state. And this is, to round up, I'm coming to what states, Muslim states and the Muslim world could do. And it has happened before. That is rational Islamic moral and ethical interventions during treaty negotiations. Now, for example, we all know, if you look at Article 20 of the UN Charter on the Rights of the Child, the issue of adoption, the Muslim states brought in an indicator, look, in Islam we don't do adoption because it is a lie. You cannot just lie. You don't want to, a child that is not your biological, we don't do adoption as is commonly. So when this was rationalized, the alternative of kafala was brought in. So you find out, and if you look at Article 20, you find it. Similarly, if you look at the Rome Statute of the ICC, if you look at Article 7, paragraph 3 of it, countries like Iran and other Muslim countries argued strongly because at that time, the issue of, gender, moving gender beyond the male and female sex was really very ripe. The Muslim majority countries rationalized, they argued that, well, look, this cannot be right. And therefore, they pushed, through rationalization, they put in, and if you look at Article 7.3 of the ICC Rome Statute, it said, for the purpose of this statute, it is understood that the term gender refers to the two sexes, male and female, within the context of society. The term gender does not indicate any meaning different from the above. So you find out that it's rational Islamic ethical interventions, and Muslim majority countries need to wake up to that to be able to do that. Now, in relation to, Muslim states' interpretation of the public moral clauses, as I said, this paper, I'm still working on it. And I will throw it as a possible discussion. Do we think now, for Islamic law to be able, or Islamic ethics to make a contribution, the public moral clauses, should they be universalistic in interpretation or particularistic in interpretation? So it's really very, very important that perhaps maybe this could be one of the questions that we could. Now, how far should, when we come to freedom of religion, how far should other religions be restricted on grounds of public morality in Muslim majority countries? I will tell you one example. Even within Islamic norms, even within Islamic states, before you bring it to the non-Muslim states. In 2012, about 100 Nigerian Muslim women, pilgrims, they went for Hajj, but they were not allowed in. They sent them back. They said all of them should go back because they didn't have mahram. There was no man. A man was not available in the plane. The Nigerian government protested. It says now, no, you cannot do that. We are Malikis. Nigeria follows the Maliki school. In the Maliki school, women can travel without a mahram as long as they travel in a group. Did you get the point? As long as they travel in a group, it's about protecting them. The Saudi government insisted, saying, now the argument is this, even within Islam, if you want to use the ethical, which one do we follow? Do we say that we will follow the Saudi perspective, the Hanbali, that, well, always there must be a man? Or does Nigeria have a right to say that, well, look, the interpretation of the Maliki school is about protection. Women can travel in a group. As long as they travel in a group, there's no... They eventually resolved it, diplomatically. And the women were allowed to come back. But they turned them back, and then it was really a hackle. So even within Islam, when we talk about public morals, ethics, which ethics are we talking about? You get the point. I mean, does it cut across, or an ethic particularistic in each country, in each school, in each country, or a universal ethic? So it's not as simplistic. So all this we need to... Now look at the issue of blasphemy, for example, freedom of expression. It's one of the major areas. I've just written an article on blasphemy, particularly in relation to Pakistan, which I've shared with my colleague there. Now, you find out that, when we talk upon public morals, particularly in relation to, Shatam al-Rasul, that is, people who abuse the Prophet and things like that. But you find out that, my argument is this. There's a need, you cannot really just use ethics. Law has to come in here to protect. I have had people, for example, in my class, people from, when we discussed this, a student from Pakistan, they said, oh, no, we don't, even if anybody abuses the Prophet, we don't need to wait for the state. And they will cite the hadith, some hadith narrated by Abu Dawud, in which, some woman was said to have abused the Prophet.
Between Islamic law and international human rights law from the University of Nottingham. And it is a very interesting research, by the way, and I wish all of you can find time to go through it. Well, I'm sure that many of you have questions and comments, but I will leave this until we finish from our second speaker. Our second speaker is Dr. Mu'taz, who is Associate Professor of Methodology and Ethics and the coordinator of the Master Program in Applied Islamic Ethics at CIS, and the Research Center for Islamic Legislation and Ethics, which is nicely called CILE. So, Dr. Mu'taz, I will give you also 25 to 30 minutes, and then we will open it for questions and comments. Thank you.
شكرا دكتور مصطفى. سأتحدث بالعربية، ولكن سأجمع بين اللغتين حتى الأفكار المركزية واضحة لتلافي أي مشكلة في الترجمة، خاصة فيما يتعلق بالمصطلحات التقنية، المصطلحات الخاصة في حقل الفقه الإسلامي تحديدا. حديثي اليوم سيكون بعد بسم الله والحمد لله والصلاة والسلام على رسول الله. سأتحدث اليوم حول منظومة الحقوق في الفقه الإسلامي، وخاصة في الأزمنة ما قبل الحديثة، أي ما قبل الدولة الحديثة. الحجة المركزية هنا أو الفكرة المركزية التي أجادل حولها أو أجادل إثباتها هي أن الفقه الإسلامي ينطوي على منظومة حقوق تقوم على ركنين مركزيين. الركن الأول فلسفي ونظري، يتمثل في مفهوم الأهلية كما هو مقرر في الفقه وأصول الفقه، والركن الثاني هو عملي وتفصيلي، يتمثل في منظومة معقدة من الحقوق التي تغطي مستويات متداخلة من العلاقات، تشمل العلاقة بالذات أو العلاقة مع الذات، والعلاقة بالله سبحانه وتعالى، والعلاقة Okay. I'm sorry. Yeah. إذن الحجة المركزية اوكي تمام. Is it working now? Is it fine now? Should I start?
Yes.
Okay. Okay, thank you very much. الحجة المركزية التي أسعى لإثباتها هنا في هذه الورقة أو في هذا العرض على الأقل هي أن الفقه الإسلامي ينطوي على منظومة من الحقوق تقوم على ركنين مركزيين. الركن الأول متعلق هو فلسفي نظري، يتمثل في مفهوم مركزي في الفقه الإسلامي وأصول الفقه، وهو الأهلية. والركن الثاني لهذه المنظومة هو عملي تفصيلي، يتمثل في منظومة معقدة من الحقوق تغطي مستويات متداخلة من العلاقات، تشمل العلاقة بالذات، العلاقة بالنفس، والعلاقة بالله سبحانه وتعالى، والعلاقة بالآخرين، وأيضا العلاقة بالحيوان. وتستوعب هذه المنظومة البعدين الأخلاقي والقانوني معا كما سأوضح فيما بعد، وأيضا تشمل الأبعاد الفردية والجماعية في نفس الوقت، وتشمل مختلف مراحل الحياة، تلازم الإنسان في مختلف مراحله من مرحلة الجنين كما سأوضح فيما بعد، ومرورا بالولادة وما بعدها، وأيضا تشمل الحياة وبعد الممات، حقوق الإنسان بعد الموت. فإذا هذه هي المنظومة، هذه أبعاد المنظومة، هذه الحجة. على مستوى المنهج سأحاول أن أقدم قراءة داخلية هنا لفقه ما قبل الدولة الحديثة، منظومة الحقوق في فقه ما قبل الدولة الحديثة، و على مستوى المرجعية والغايات أيضا سأحاول أن
أوضح كيف أن المنظومة الفقهية للحقوق تتأسس على بعدين مركزيين، عقلي وشرعي. شرعي هنا revelation reason and revelation، وعلى مستوى أيضا تجمع بين أو يتداخل فيها مفهوما الحق والواجب، فكل حق هو واجب وكل واجب هو حق، فيصعب الفصل بين المفهومين هنا في منظومة الحقوق في الفقه الإسلامي. وأيضا هناك تداخل بين حقوق الله وحقوق العباد أو الآدميين أو المخلوقين، يجعل من إنسان الفقه الإنسان الذي يتصوره أو في التصور الفقهي ما قبل الحديث، يجعل من إنسان الفقه مفارقا لإنسان الرغبات والشهوات ومن جهة، ويجمع بين إنسان التكليف والإنسان صاحب الحقوق الذي له حقوق من جهة أخرى. حتى أوضح هذه الفكرة المركزية هنا سأتناول 4 محاور كما تبدو على الشاشة. المحور الأول هو مدخل حول التفاعل الإسلامي الحديث مع خطاب حقوق الإنسان، والثاني المحور الثاني يتناول ميادين البحث في الحقوق في الموروث الإسلامي، والثالث يناقش الأهلية، مفهوم الأهلية بوصفه أساسا فلسفيا للحقوق عند فقهاء ما قبل الدولة الحديثة. والمحور الرابع والأخير وهو منظومة الحقوق كما تبدو في إطارها في إطارها العملي. سأعتمد هنا تحديدا التصور الذي قدمه الإمام عز الدين بن عبد السلام الذي توفي سنة 660 للهجرة في القرن السابع الهجري. طيب، الآن سأنتقل إلى المحور الأول. فيما يخص المحور الأول، فكرة حقوق الإنسان في المفهوم الحديث أثارت الكثير من النقاشات في السياق الإسلامي. طبعا سأضع نقاطا مركزية فقط، لن أفصل في هذا، ولكن أريد أن أشير هنا إلى نقطة مركزية، وهي أن جل الكتابات الإسلامية حول حقوق الإنسان في السياق المعاصر كانت مسكونة بهاجس الغرب، إما بالمقايسة عليه أو لإثبات التفوق عليه أو أننا سبقناه إلى هذه الحقوق، أو في سياق لإثبات المفارقة والتميز عن السياق الغربي. ففكرة حقوق الإنسان الغربية كانت هي محورية في إثارة كل هذا النقاش المعاصر. سأشير إلى ثلاث مراحل هنا، يعني حتى أنتقل إلى المحور الذي بعده. أو قبل ذلك لابد أن أشير هنا أننا يمكن أن نميز بين توجهين في مسألة استلهام الفقه الإسلامي، فقه ما قبل الدولة الحديثة مرة أخرى، في السياق الحديث، في سياق النقاش الحديث حول حقوق الإنسان. هنا يمكن أن نميز بين توجهين. التوجه الأول هو نهضوي، التوجه النهضوي الذي يمكن أن نلمس مراحله الأولى أو بوادره الأولى مع رفاع رافع طهطاوي. رفاع رافع طهطاوي توفي سنة 1873. رفاع طهطاوي كان في بداية القرن التاسع عشر، كان من المبكرين الذين حاولوا أن يستلهموا الفقه الإسلامي في سياق البحث عن منظومة الحقوق بما يتناسب مع مواريث التنوير الفرنسي، حركة التنوير في فرنسا، وخاصة أنه ترجم الدستور، مواد الدستور الفرنسي أيضا في ذلك الوقت، في ثلاثينيات القرن التاسع عشر على ما أذكر. الآن هناك نقطتان مركزيتان عند رفاع رافع طهطاوي. النقطة الأولى هي أنه تحدث عن حقوق الرعاية بما يشبه مفهوم حقوق المواطنين، والثانيا هو حاول أن يربط بين منظومة الحقوق وأبواب الفقه الإسلامي. يعني مثلا يقول هذه الحقوق هي في كتب الفقه عبارة عن المعاملات والأنكحة والفرائض والوصايا والحدود والجنايات والدعاوى والبينات. ليس بالضرورة أن تترجم كل هذه المصطلحات التقنية الآن. عموما يعني الفكرة المركزية أنه حاول يربط بين أبواب الفقه كما هي مقررة في الكتب الفقه الكلاسيكية ومنظومة الحقوق كما بدت له في الموروث الفرنسي أو في فكر التنوير الفرنسي بشكل مجمل ليس بشكل تفصيلي. طبعا هذا التوجه الأول هو التوجه النهضوي. التوجه الثاني هو توجه أسميته توجها هوياتيا، وهنا يعني أستطيع أن أركز على ثلاث مراحل. المرحلة الأولى في الأربعينيات مثلا من القرن العشرين، كان هناك التركيز كان على فكرة التمايز عن المنظور الغربي لحقوق الإنسان. في الستينيات نجد أن التركيز على أننا سبقنا الغرب في الإقرار بفكرة حقوق الإنسان. في الثمانينيات نجد أن محاولة كثير من الإسلاميين صياغة بيانات إسلامية لحقوق الإنسان وفق المنظور الإسلامي تتجاوز التحفظات التي أبدوها على ميثاق العالم لحقوق الإنسان. هذه فقط لفهم الخلفية التاريخية أو كيف تمت مناقشة في سياق كيف تم استلهام الفقه أو الموروث الفقهي في السياق الحديث. سأنتقل هنا إلى المحور الثاني الآن سريعا حتى لا يدركني الوقت، وهو ميادين كيف تم البحث أو كيف تمت مناقشة فكرة الحقوق في الموروث الإسلامي. طبعا هناك أدبيات واسعة جدا في التراث الإسلامي تناقش فكرة الحقوق، وفكرة الحقوق أعني فكرة الحقوق هنا بالمعنى المطلق، ليس حقوق الإنسان فقط يعني بالمفهوم الحديث. ويمكن لي أن أميز بين ثلاثة مستويات هنا أو ثلاثة أنواع من النقاش أو ثلاث مقاربات دعني أقول. المقاربة الأولى متعلقة بتناول أنواع مختلفة من الحقوق أو نوع معين منها. هنا مثلا نجد أنه كان هناك من صنف في حقوق الله مثلا. في القرن الثالث الهجري بدأ التصنيف في فكرة حقوق الله على العباد. بدأ ذلك مع الإمام الحارث المحاسبي الذي توفي سنة 243، وبعد ذلك التراث الصوفي بدأ ينشغل كثيرا بفكرة حقوق الله على العباد. هناك من صنف في حقوق المصطفى صلى الله عليه وسلم، حقوق الرسول على أمته، ومن أبرز من صنف في هذا وكان له انتشار واسع جدا عبر القرون هو الإمام القاضي عياض. القاضي عياض كان في القرن السادس الهجري في الأندلس، وكتابه يعني انتشر انتشارا هائلا في القرون اللاحقة. فهو يبحث عن حقوق المصطفى على المسلمين. هناك من صنف في أنواع مختلفة أخرى من الحقوق، حقوق مثلا حقوق الراعي وحقوق الرعية وحقوق الإمام الراتب في الصلاة. وهناك الإمام الشعراني مثلا صنف في كتابا جمع فيه أنواعا مختلفة من الحقوق. هل هناك مشكلة في الترجمة؟ هل كل شيء تمام؟ ما زلت في المحور الثاني. الآن الأخوة مثلا الإمام الشعراني يتحدث عن حقوق أخوة الإسلام. الإمام الشعراني يتحدث عن حقوق أخوة الإسلام، وهنا جمع أنواع مختلفة من الحقوق كما قلت. مثلا تحدث عن حقوق المسلمين بعضهم على بعض، ومعاشرة الصديق مع الصديق، والشيخ مع المريد، والعالم مع المتعلم، والأمير مع الرعية، والجار مع الجار، والضيف مع المضيف، والوالد مع الولد، والغني مع الفقير، والزوج مع الزوجة، والقريب مع الغريب، والمسلم مع الذمي. وأيضا هناك نوع لطيف من الحقوق تحدث عنه وهو حقوق المبتدع، أن حتى المبتدع الذي يعتبر أنه خالف الكومن موراليتي الأخلاقيات العامة له حقوق أيضا، فهو يتحدث عن حقوق المبتدع أيضا وشرائطه وأدابه. في بعض الكتب أيضا نجد أنواعا مختلفة من الحقوق، مثلا باب باسم تحت عنوان حق الوالدين أو حق الصحبة أو غيرها. على مستوى الديسيبلينز تخصصات، هناك مجالات أو تخصصات متنوعة داخل الفقه الإسلامي غطت جوانب مختلفة من الحقوق. مثلا في التقليد الصوفي مثلا يركزون بشكل رئيسي على حقوق الله على العباد. في كتب القضاء أيضا تركز على الجانب القانوني من الحقوق، ولدينا أدبيات كثيرة في القضاء. هناك أيضا كتب الأحكام السلطانية والسياسة الشرعية تركز على حقوق الراعي والرعية. هناك أيضا نوع معين من الكتابات يتحدث عن أحكام البنيان والعمران في التاريخ الإسلامي. في هذا النوع من الكتابات، وهي عديدة، صنف فيها فقهاء وأيضا مشتغلون بالعمارة وغيرها، صنفوا في هذا النوع، تحدثوا عن حقوق المرتبطة بالعمران، بالجوار وما يرتبط بالعلاقة بين السكان فيما بينهم. يتداخل فيها البعد الاجتماعي مع البعد العمراني في هذا النوع من الأدبيات. أيضا كتب التاريخ والرحلات تناقش البعد العملي، وهذا تم تجاهله في الكتابات الإسلامية الحديثة التي تناولت الحقوق من منظور نصي فقط ونظري، لأنها كانت مشغولة بالسجال والمقارنة مع الفكرة الحقوق الغربية، ولكن لم يتم استكشاف البعد العملي التطبيقي في التاريخ الإسلامي لمنظومة الحقوق، كيف اشتغلت هذه المنظومة. فهذا النوع من الكتابات المتعلقة بالتاريخ والعمران وغيره والقضاء تجلي الجانب العملي من منظومة الحقوق، أنها كيف اشتغلت في سياق الحضارة الإسلامية. لكن أبرز حقلين تخصصيين اشتغلا على منظومة الحقوق بطريقة شاملة وتجمع بين الإطار النظري الفلسفي أو البنية النظرية وبين الإطار العملي التطبيقي، هما حقل الفقه وأصول الفقه. على المستوى الثالث هنا استطيع أن أشير أيضا إلى أن ثمة بعدا مؤسسيا. هناك مجموعة من المؤسسات في الحضارة الإسلامية اشتغلت على تحصيل ووضع ضمانات لتحصيل الحقوق. من ذلك مثلا ابن خلدون المؤرخ الشهير الذي توفي سنة 808 للهجرة يتحدث عن 3 مؤسسات فقط على وجه التحديد أقصد، اشتغلت على تحصيل الحقوق في الحضارة الإسلامية. مثلا وظيفة القضاء مثلا يسميها وظيفة، هي مؤسسة بتعبير اليوم، ووظيفة العدالة التي مرتبطة بحقوق بالشهود والإجراءات، وتبحث في حقوق الناس، كيفية تحصيل حقوق الناس، وديوان يسميه ديوان الأعمال والجبايات، وهو يبحث في تحصيل حقوق الدولة، يعني الحق العام. فهذه 3 وظائف أو يسميها وظائف هو ارتبطت بإطار مؤسسي لتحصيل أنواع مختلفة من الحقوق، إما تتعلق بالحق العام أو بالحق الخاص المرتبط بالأفراد. سأنتقل إلى المحور الثالث هنا، وهو الأهلية بوصفها أساسا فلسفيا وأخلاقيا للحقوق. الأهلية لابد أن نوضح بداية أن الأهلية مفهوم مركزي هنا، لأنه يقدم إطارا فلسفيا لفكرة الحقوق في المنظور الفقهي ما قبل الحديث، ومعناه أن يكون الشخص أهلا للإيجاب عليه والوجوب له، يعني أن يكون أهلا لوجوب الحقوق له ولإيجاب الحقوق عليه أيضا. فإن يكون صاحب حقوق أو يتمتع بأهلية تمكنه من أن يكون موضوعا للحكم بالإيجاب له أو عليه بشكل بسيط. يعني الآن مفهوم الأهلية هنا من المهم جدا أن نشير إلى أن مفهوم الأهلية عند الفقهاء، ومن أوائل من صاغ صياغة مبكرة جدا لهذا المفهوم بطريقة فلسفية هو الإمام القاضي أبو زيد الدبوسي بتخفيف الباء. توفي أبو زيد سنة 430 للهجرة، أي 1039 للميلاد. وتتابع فقهاء الحنفية خاصة وبعض فقهاء الشافعية على هذا المفهوم للأهلية فيما بعد. هنا يقدم مفهوما للأهلية يكاد يتطابق مع إحدى صور مفهوم الحق الطبيعي الذي نعرفه اليوم، لأن الأهلية تنقسم إلى قسمين هنا. أهلية الوجوب وأهلية الأداء. أهلية الوجوب التي شرحتها من قبل، وهي أنه أن يكون أهلا، الشخص أهلا لأن يجب له حقوق وأن يجب عليه حقوق، أن يكون مكلفا بها، فصلاحيته لأن يكون موضوعا للحكم. هذا النوع من الأهلية يثبت بمجرد ولادة الإنسان حين يولد كما يقول، بمعنى أنه لا مبرر أو مسوغ لهذا النوع من الأهلية إلا كونه آدميا وكونه إنسانا. بمجرد ولادته تثبت له هذه الأهلية، أهلية الوجوب. فهنا يتساوى جميع البشر بمجرد الولادة بمنظومة من الحقوق، وهو ينص على 3 أنواع من الحقوق تحديدا: الحق عصمة النفس، يعني الحياة، حفظ الحياة، وأيضا المالكية بأن يكون له ذمة مالية، بمعنى أن يكون له الحق في الملكية، هذا معنى المالكية هنا. وأيضا أن يكون له الحق في الحرية، فهو ينص على العصمة أي عصمة النفس والدم، والحرية أن يكون حرا، والمالكية أو أن يكون له ذمة أو يكون له أهلية للتملك، تملك الأشياء. الآن فيما يخص الأهلية الأداء، هذا فيما يخص أهلية الوجوب. فيما يخص أهلية الأداء، فأهلية الأداء على خلاف أهلية الوجوب. أهلية الوجوب تثبت بمجرد الولادة كما قلنا، ولكن أهلية الأداء هي أن يكون مؤهلا أو قادرا على تنفيذ الحقوق، وضعها في إطار التنفيذي. وأهلية الأداء مرتبطة بأمرين: أن يكون صالح من الناحية العقلية، وأن يكون صالح من الناحية البدنية، الناحية الجسدية، لتنفيذ أو القيام بهذه الحقوق أو التي وجبت في ذمته. فهنا نتحدث عن الأهلية، أن أهلية الوجوب مرتبطة بمفهوم معنوي اسمه الذمة، والذمة هو مفهوم مرتبط بفكرة العهد والميثاق الذي أخذه الله من ظهور بني آدم في الأزل، وهو الأساس الذي تبنى عليه فكرة حقوق الله على العباد، فكرة الأمانة أو العهد أو الميثاق. فهو أساس فكرة أهلية الوجوب عند هؤلاء الفقهاء، خاصة بداية من أبي زيد الدبوسي إلى وانتهاء بعدد من الفقهاء وهو أصبح المين ستريم، أصبح التيار الرئيسي في الفقه الحنفي خاصة. فإذا هنا بناء على مفهوم الأهلية بقسميه، أهلية الوجوب وأهلية الأداء، نستطيع أن نميز بين 3 أنواع من الكرامات التي كرمها بنو آدم عموما من قبل الله عز وجل. وهي هذه الكرامات ال3 قائمة على 3 مفاهيم. مفهوم الأول الآدمية هو مفهوم سابق على فكرة الإنسانية، بمعنى أن الآدمية ليس بالضرورة أن تكون نفسا ذات ذمة بالمعنى القانوني. الآدمية مرتبطة بمرحلة الجنين، فحرمة الآدمية مرتبطة بالجنين الذي بدأت تتشكل فيه معالم أو صورة جسد أو عضو من الجسد الإنساني. فهنا يعطي الفقهاء حرمة ومكانة خاصة، كرامة خاصة للمضغة المخلقة، المضغة المخلقة التي بدأت تظهر عليها علامات 5 دقائق علامات أو صورة إنسان، يد أو رجل أو ما شابه ذلك. فهنا نعطيه حق الآدمية أو كرامة الآدمية، لأنه بدأ يتصور إنسانا، ولكن لم يصبح نفسا بعد. المفهوم الثاني من الكرامة هو كرامة الذمة التي تحدثت عنها، وهي العهد والميثاق. فالله حمل بني آدم الأمانة منذ الأزل. والمفهوم الثالث العقل هو المرتبط بفكرة أهلية الأداء، لأن بالعقل والتمييز يصبح الإنسان أهلا للإيجاب عليه، ويصبح فعله معتبرا من الناحية الفقهية والأخلاق، من الناحية القانونية والأخلاقية. انتقل إلى المحور الأخير، وهو منظومة الحقوق. كما تبدو لدى الإمام العز الدين بن عبد السلام. نستطيع أن نرسم خطاطة للحقوق التي رسمها الإمام أو وضعها الإمام عز الدين بن عبد السلام، كما صاغها، أقصد لم يضعها هو ولكن صاغها صياغة مبكرة بشكل شامل. الإمام عز الدين بن عبد السلام توفي سنة 660 للهجرة كما قلت، أي 1262 1262. المنظومة التي وضعها الإمام عز الدين بن عبد السلام تدور على قاعدة أو مبدأ جلب المصالح ودرء المفاسد، وهو يقسم منظومة الحقوق ككل إلى قسمين رئيسيين. القسم الأول حقوق الخالق، والقسم الثاني حقوق المخلوقين، وعن هذين النوعين تتفرع مجموعة واسعة من الحقوق. فنستطيع أن نميز مثلا بين في حقوق الخالق عز وجل، هو يقسم حقوق الخالق عز وجل إلى 3 أنواع أيضا، لن أفصل فيها الآن لم يعد لدي وقت كبير. وفي ما يتعلق بحقوق المخلوقين أيضا يقسمها إلى 3 أقسام: حقوق المكلف على نفسه، وحقوق المكلف على حقوق بعض المكلفين على بعض، وحقوق البهائم والحيوان على المكلفين. فهو يبحث في هذه الأنواع ال3، وكان طريفا جدا أن يدرج حقوق الحيوان على الإنسان ضمن هذه المنظومة في زمن مبكر في القرن السابع الهجري. ثم جميع هذه الحقوق يقسمها إلى قسمين: ما هو objectives مقاصد، وmeans وسائل. ثم يبحث في مصفوفة هذه الحقوق، إذا تعارضت هذه الحقوق بعضها مع بعض كيف نوازن بينها، فيضع مجموعة من التقسيمات، حوالي 7 تقسيمات أو 8 تقسيمات، لا يوجد وقت للخوض فيها الآن، لوضع معايير للموازنة بين الحقوق المتعارضة، سواء فيما يخص حقوق الله الخالق أو حقوق العباد. وفي الختام، حتى أكون ملتزما بالوقت، دقيقة أظن بقية، في الختام أود أن أؤكد على فكرة أن حقوق الإنسان وفق شريعة ما قبل الدولة الحديثة لا تنفصل عن منظومة متكاملة. حقوق الإنسان لا تنفصل عن منظومة متكاملة من الحقوق وفق شريعة ما قبل الدولة الحديثة. فهي تخاطب الإنسان العمودي، أي الحقوق تشمل بعدي الدنيا والآخرة، وملازمة منظومة الحقوق هذه ملازمة لألوان الفعل الإنساني وحركته في الكون، فتشمل 4 مستويات: العلاقة بالذات وبالله وببني جنسه وبالحيوانات. والحقوق وفق المنظور الفقهي لا تقدم أو لا تقف عند حدود المفهوم القانوني للحقوق، بل تشمل أنواع كثيرة من الحقوق الأخلاقية والمعنوية التي ليست محلا للتقاضي، وبعضها محل للتقاضي وبعضها ليس محلا للتقاضي أصلا. ومنظومة الحقوق هذه تأسست على فكرة العهد أو الأمانة، كما عبر عنها الفقهاء والأصوليون بالأهلية، كما قلت أهلية الوجوب خاصة، التي تثبت بمجرد الولادة بوصف الإنسانية، بمجرد الإنسانية، بمجرد الولادة تثبت له أهلية الوجوب كما قلت، فيتساوى فيها بنو آدم بغض النظر عن أي فروق بينهم. وهي تقدم صورة من صور الحق الطبيعي، ولكن الله فيها مركزي هنا، ولكن لأنه فكرة الحق الطبيعي تطورت ولها صيغ مختلفة، ولكن هذه الصيغة إذا كنا سنطابق بينها فهي تطابق مع فكرة الحق الطبيعي التي الله سبحانه وتعالى يشغل فيها دور المركز. والآدمية أيضا وهي ظهور بعض ملامح الجسد في الجنين، الجسد الإنساني طبعا، لها حرمة ترتب حقوقا سابقة على فكرة النفس ذات الذمة بالمفهوم القانوني. وهذه المنظومة تأسست على مفهوم العهد والأمانة كما قلت، فخاطبت الضمير الفردي والأخلاقي ابتداء، ولكنها أيضا وفرت أطرا قانونية ومؤسسية لبعض أنواع الحقوق في ظل نظام ما قبل الدولة الحديثة التي تمتعت بسلطة محدودة في التدخل في حياة المجتمع والأفراد بالمقارنة مع سلطة الدولة الحديثة. الحمد لله.
Thank you very much, Dr. Mu'taz. Very interesting talk. By the way, Dr. Mu'taz has many publications You'll get some of them in the magazine CILE, which you might get some of them outside. And we have about 25 to 30 minutes, which is going to be for questions, comments, and so on. And if you don't mind, let me start by raising the first question to Professor Mashoud. My question is linked to, let us take the word credibility, مصداقية, credibility. The advocator of human rights in the West, when you look at the implementation of the human rights from their side, this will bring us to the word credibility or مصداقية. So this credibility, is it affecting, for example, let us take our side from the East or from the Islamic world, is it affecting our readiness to go with them for the implementation of the human rights? In another word, for example, when you look at Islam, the Quran said, وَلَا يَجْرِمَنَّكُمْ شَنْآنَ قَوْمٍ عَلَىٰ أَلَّا تَعْدِلُوا, which means that justice for all. And the Prophet ﷺ is saying that وَأَيُمُّ اللَّهِ لَوْ أَنَّ فَاطِمَةَ بِنْتُ مُحَمَّدٍ سَرَقَتْ لَقَطَعْتُ يَدَهَا, which means that, and the hadith is very long, إِنَّمَا أُهْلِكَ مَنْ كَانَ قَبْلُكُمْ أَنَّهُ كَانَ إِذَا سَرَقَ فِيهِمْ الشريف تركوه وإذا سرق فيهم الضعيف أقاموا عليه الحق. So here, when you look at the practice of the advocator of human rights in the West, in different parts of the world, then it reflects on, for me, even credibility is part of ethical. I cannot separate credibility from the ethical when I talked about ethical implementation. For example, معتز talked about منظومة الحقوق في الفقه الإسلامي التداخل بين الأخلاق والقانون. If I'm going to deliver a similar speech about the West, I will talk about منظومة الحقوق في الغرب التداخل بين القانوني والأخلاقي والمصلحي, because it seemed to me the interest here is getting in for when it comes to the implementation of the human rights. So the credibility, the word credibility is the key word which I would like you to comment on it. Thank you very much.
Thank you very much, Dr. Lamin. You've raised a very important point in relation to implementation is the third leg of international human rights. Has 3 legs. The first one is the conceptualization, which is theoretical, conceptualizing it, many of which we're talking about now. Then the second level is standard setting, that is setting the standards, minimum standards, like these are the standards. We have this in the instruments. Then the third leg is the implementation. In my writings, I've indicated a lot of the time when we talk about human rights, we forget that there's this concept of the politics of human rights. Human rights has a politics, and its politics is its problem. It's not the legal or the ethical, it is the politics. And you did mention that, when we look at the West. Now, when you look at the West, you are starting looking at the politics of human rights. You wouldn't find any human rights instrument that says that you can do double standards, that apply to this, don't apply to that. Every human rights instrument is equitable. But you cannot judge human rights by the practices of the West. That is the politics of human rights. Similarly, if you come to Islamic law, there are so many nice verses in the Quran, as you write, legally and ethically. A lot of the time, Muslims behave badly. A lot of the time, they behave bad. That's the truth. Muslims behave badly. Muslim states behave badly. When they behave badly, We tell them that, look, this is not what the Quran is saying. We don't judge the Quran by the acts of the Muslim states. So it is just human. The politics, similar people talk about, Islam, political Islam, whereby the rulers will leave what the Quran or the Sunnah is saying. They'll do something else. So it's the same thing. There's no, a lot of the time I say this, don't judge this. When I go to conferences, one of the counter question I receive is this. When I start talking, especially from conceptualization, citing all the nice verses in the Quran, this is human rights, this is ethics. Sometimes, I try to explain, and I can point to maybe 2 countries. Somebody will ask, look, these are really very nice. Can you point to 2 Muslim countries that practice this thing that you are saying? A lot of the time it embarrasses me. They say, look, everything you are saying is very good. Tell us 2 countries where we can find all these things that you are talking practice. Sometimes I struggle, I mention Morocco. I mention Morocco, and I struggle too. So it's the same thing. There's politics in Islamic law, Islamic ethics. There's politics in human rights. It's about us, human beings, not the laws themselves. So this, I hope this answers the question.
Thank you. Mm-hmm. Thank you. Answer part of it, in fact, because I'm talking about the advocator, because you are not going to get many Muslim states who are now advocating human rights because of many reasons behind. But the Westerners are the ones who are advocates of the human rights, and they want to implement it on us. We are accepting that. We want to implement it. But one of the things which making us reluctant is when we see the practice, the credibility of those who are advocates. If a Muslim come and he want to be advocate of human rights in the West, I will say to him the same thing. But now the Westerns, they want to implement human rights on us, but they are not implementing it in a credible way. Thank you.
I'm sorry. If I may respond to that. In relation to the advocate, when we talk about universal human rights, in my writings, I talk about universality and universalism. Everyone, all states, even Muslim states, are advocates of human rights. Look, there is no Muslim country today that will say that, well, let human rights go to hell, that we don't want it. Even when they violate human rights, they say we don't violate it, because they believe it is important. Even when they violate it, they say, no, we are not violating human rights here. They are advocates, either negatively or positively. You find Muslim countries indicating, look at the OIC. The OIC advocates, it has declarations, OIC Declaration on Human Rights in Islam. They don't implement it. They just have it. They don't implement it. That's just the truth. They advocate it. There are treaties that they adopt. In the negotiation of treaties, I do mention to you, it's about negotiation. Muslim countries negotiate. They try to. So I'm not in a position, I do not agree with the fact that, well, human rights are only advocated by the West. Every nation state, they will say, there's no country in the world today that will say that, no, we don't believe in human rights. The only problem is about its universalism. That is its interpretation and its scope. But to say that only West advocate human rights, then why are we here? We are actually advocating it now. This is why we are talking about it. Otherwise, I agree that there's double standards. There's a lot of double standards in the West. And even non-Muslims challenge it. Non-Muslim human rights writers, commentators, they challenge it. When the United States violates human rights, you see people challenge it, not Muslims. People who believe in the concept of human rights, they critique it, they challenge it.
Okay, thank you very much. So now those who are taking the microphone, could you please be ready? We will start by, yes, you please. Yeah, you introduce yourself and then ask your question, please.
I'm assistant professor and head of human rights program at Doha Institute for Graduate Studies, and very happy to listen to Dr. Mashoud. I learned a lot from Dr. Mashoud at SOAS, and also thanks for your presentation, Dr. Mu'taz. My comment will be on the question of public morals. In the legal system in many Arab and Muslim countries, there is some kind of fusion between public order and Islamic law. This is something, for example, decided by Egyptian court since 1950s and endorsed by the Supreme Constitutional Court in 1970s. This could have two consequences or some kind of contradictory consequence. In one way, it could help court to expand rights under Islamic law, but also there is, and this is something I'm going to talk about tomorrow. When it comes to religious freedom and freedom of expression, public morals has been used very broadly by the court. So I think there is a need to have universalistic definition of public morals. And in one example, in 1975, the Supreme Court in Egypt decided that religious freedom is only practiced by the monotheistic religion, only three monotheistic religion. And at the same time, there is lots of restriction on religious freedom and the question of blasphemy. But also the context is different between European Court of Human Rights and its application to margin of appreciation when it comes to blasphemy and when it comes to blasphemy in the Arab region. Here the proportionality is absent in the Arab region because the law criminalizes blasphemy, and people can be sentenced to lots of years in prison. So I think it's very important. I'm not against having this fusion between public morals and Islamic law. It can work. It worked efficiently for rights of women, for example. The court has produced lots of progressive interpretation of Sharia when it comes to rights of women. But when it comes to religious freedom and freedom of expression, it does not produce the same results. The same also in Pakistan, I think. We see this contradiction between its interpretation of rights of women and the interpretation of religious freedom and freedom of expression. Thank you.
Thank you. We will take 2 or 3 questions and then Professor Ghali. Professor Ghali.
Shall I?
Professor Ghali.
There was a question here as well.
Yeah, I will come back.
They will come back to you.
Just distribute one from here, one from here, one.
Cool. Thank you very much for both presentations. I have a question about this. I'll say it in Arabic because the presentation was in Arabic. مسألة التزاوج ما بين الحقوق والواجبات. طالما في واجب إذا هناك حق وهكذا. فأنت قلت تقريبا في كل شيء. تقريبا. فمثلا إذا كان في حقوق للزوج ففي واجبات للزوجة، حقوق للزوجة، واجبات للزوج وهكذا. في ذكرك للعز بن عبد السلام ذكرت الحيوانات فقط، إنسان وحيوان. الآن في خطاب مثلا البيئة بنتحدث عن واجبات تجاه الخلق عموما، النبات، المصادر الحياة زي المياه، الهواء إلى آخره. والآن في الذكاء الاصطناعي عندنا السمارت ماشينز، الآلات الذكية وبما فيها الروبوتس اللي ممكن تكون شكل الإنسان وتؤدي وظائف يؤديها الإنسان. فرأيك ممكن منظومة الحقوق والواجبات يتم توسيعها الآن لتصل إلى هذا؟ فنقول مثلا إن للسماء حق وللأرض حق وللنبات حق وللماء حق وللإنسان الآلي حقوق، وإذا تم تجاوزها يبقى لها عقوبات أو خلافه، أو يكون الإنسان عاصي مثلا إذا أساء إلى إنسان آلي بضربه مثلا أو تكسيره أو شيء من هذا القبيل. شكرا.
Is there anyone from the last? Is there anyone from there? No? Then we'll come back to... Yes, please.
Yeah, there are too many questions. You want to answer them before you forget them? Or?
No, I've written them. I have only one. The other one is for Dr.
I reached to an agreement with the
Okay, that's
speaker.
fine. Yeah, no,
We're going to take three questions.
My name is Nias Sharma, professor in the law school at the University of Hull, United Kingdom, and a practicing lawyer. This is an observation on the implementation by Muslim states and advocating human rights by them. When you look at it, the rule of law culture in Muslim states, they don't implement their own laws, let alone the treaties they have signed. They don't. What is the rule of law in a lot of these countries? Look at the Muslim countries. I'm originally from Pakistan, but look, where is the rule of law in Pakistan? Where is the real democracy in all these countries? The real rule of law, cultures are well developed where there are really democracies. Look at the European countries and in several other states around the world. So looking at the primary sources of Islamic law, there is a rich primary sources, material. All of us are alluding to, and we will be picking on the various verses, Quran and Sunnah, and to develop our arguments. So the system is there in Islam. Muslim states contribute to the formation of international human rights treaties, what we call core human rights treaties. And Islam is the only religion which has found a way, a provision of which is included in a core human rights treaty. It's paragraph 3 of Article 20 of the Convention on the Right of Child, the kafala principle, which is included there. That means they had an input. Go to humanitarian law, we got the crescent, the symbol from the Ottoman Empire. It goes on and on. The contribution is there. The proposals were there, they're active. It's come to implementation. Here, they don't implement their own laws because there is no rule. The culture of rule of law is weak. I'll talk more in the compatibility session when I come to my own, but it could be the reasons. About hypocrisy and double standard of the West, there is no doubt about it. When they talk about human rights about others, actually they are contributing to the violation of human rights outside their borders. And you will be shocked the way, for example, the UK tried to argue their case when human rights violation by Iraqi troops were challenged in British courts and then in the European Court of Human Rights. Basically, they say we are not bound by the European Convention outside the borders of the UK, and the United States record, extra rendition, and others appalling. But US is the only country which is making annual human rights reports on all countries. And there's just only one country which is make a good annual report on the human rights violation by the United States, that's China. So you need to look at the Foreign Ministry of China, which does a really good report. There are other organizations as well, but the hypocrisy, the double standard is beyond doubt now. We all know this. Thank you.
Thank you. So now,
Yeah.
Mr. Mashoud first, and then.
Okay. Thank you very much. I mean, Mutaz, thank you very much. It's very nice to see you. I mean, I'm happy. I mean, as you mentioned that, I mean, the universalistic interpretation will be better. I will agree as well, if that is really possible across board. Now, you mentioned when you talked about Egypt in relation to the issue of, I mean, freedom of religion, that public morals have been interpreted based on Islamic norms. Yes, but a lot of the time, not only in Egypt, even in Indonesia, you find out that, I mean, when we talk about freedom of religion, the public morals perspective of Islamic law, it's about Adyan Samawiya, that is Abrahamic religions, and that's what we think of. Now, atheists and other human rights, when we talk about beliefs and religions, it also, you have to respect the beliefs of the atheist, even. So if you want to look at it, I mean, classical Islamic sources may not accommodate atheists, for example, I mean, in relation to that. If, I mean, countries where they exist, you know, there have been a lot of issues in, for example, in Indonesia, only 5 religions are recognized by law, including Baha'is and others. But there are others who have other, how do we deal with that? If we say if you say universalistic approach, then the ethics must apply to everybody. Do you get the point? You have to let them do. In some countries, even, I mean, in some Muslim countries, even the, I mean, people of the book, I mean, the Abrahamic religions, they cannot build their churches, so they are, I mean, it's different in the Gulf states here. But in many Muslim countries, even in my own country, Nigeria, in the northern part of it, Christians complain a lot. They apply for land to build churches. They said, no, it's not available. So, I mean, when we say universalistic, are we able to stretch to go the long stretch? Or perhaps, I mean, so, and the issue of, I mean, maybe Egypt, yes, I've not checked on most of the comments of Egypt. But even Muslim majority countries, they themselves put Islam or Islamic morals on trial at the human rights institutions. For example, in the state report of Jordan, Mauritania, and Morocco, they have reported, when they are talking about these public morals, they say that, for example, Jordan says that in Jordan, public morals are based on Islamic morals. They themselves say it. They say public morals, Islam forms part of public morals in Jordan. Islam forms part of public morals in Morocco. And also you see, so when they bring this out in their report, it's like putting Islam on trial, indicating that, so you have to do better. You should be able to do better. If you say that, well, Islamic morals ethics can promote human rights properly, they have to show it in there. I agree that in the sources, yes, we have cited so many provisions that they can, but it's in the implementation. Let the states come forward and implement. Sometimes it can be difficult, and this is what I said. If we look at it, many of the classical limitations, many of the classical interpretations, my argument is that there's the possibility of moving away from them. Now, for example, even using principles of takhayyur, which I say is an ethical principle. We can find, if the Hanbali school says something, you may be able to find a more human rights friendly in the Maliki school. You may find a more human rights friendly in the Hanafi school. What stops us moving between the schools? It's our own laws. Do you get the point? Even in Egypt, in relation to women's right to divorce, they did this, they came to the Maliki school to give women the opportunity to get out of marriages. This is what I'm saying. We can do that, and it's part of ethics, of not really restricting ourselves to the hard line. We can move between schools and have, so I hope this answers your question.
Thank you. Dr. Mu'taz.
فيما يخص السؤال، شكرا دكتور مصطفى. أنا كنت أتحدث عن منظومة الحقوق عند الفقهاء قبل الدولة الحديثة، ولذلك أخذت العز بن عبد السلام كنموذج. هو لم يتحدث عن ذلك، ولا أعرف حتى الآن لا أعرف أحد من الفقهاء الكلاسيكيين تحدثوا عن حقوق تجاه بنص صريح، أقصد في تصنيف الحقوق. ولكن هذا لا يعني أن الحق هذا غير موجود في التراث الإسلامي. كنت أتحدث عن الفقهاء ما قبل الدولة الحديثة وفي المنظور الفقهي. ولكن نحن نعرف طبعا إذا كنا نتحدث عن الإسلام كتراديشن ككل، طبعا القرآن دائما يتحدث عن يسبح لله ما في السماوات وما في الأرض، فبالتالي حتى المنظور القرآني للكون على أنه كائن حي، بمعنى أنه يمكن أن يسبح ويسجد، ولله يسجد ما في السماوات وما في الأرض، وما هنا لغير العاقل إذا أخذنا التفسير الحرفي. فبالتالي المنظور القرآني مختلف قليلا هنا، فنستطيع أن ندخل حقوقا أخرى طبعا في المنظومة إذا وسعنا دائرة البحث. ولكن أنا كنت فقط أتحدث عن نموذج العز المصفوفة التي قدمها الإمام عز الدين بن عبد السلام، وعن منظومة فقه ما قبل الدولة الحديثة، ولكن نستطيع أن نضيف إليها طبعا. هذه نقطة. النقطة الثانية فقط أريد أن أشير إلى نقطتين. I just would like to I have just two comments here. One is related to the example that you mentioned before about the prophetic argument about committing a zina, in terms of, that he said, do you accept it? Do you accept it for your mother? So I think we have to be cautious here dealing with this type of argument. I understand your point that you are going to stress the relying on rationale of ethical reasoning, but I think here it's the same time it has a double sides here, because this argument is invalid now in many cultures, because they do. So it's related to the urf, the social practice, and we know that in some other cultures they try to, even they train their children to have relationships under their supervision. So in other cultures is different. So the argument is based on or enhanced in the social norms. The other point here is also related to the gap between the ideal law and the practice. So there's always the gap between the ideal law and the practice, and it will remain there. Okay. So, but now we have to be cautious dealing with the way that this gap can be instrumentalized by the state or politicians, and one of these instrumentalized practice is the being selective. You know, some political rulers in the Islamic in the pre-modern time in the Islamic tradition, they used to, especially in the Mamluki period, they used to move from one fiqhi tradition to another to manipulate the morality, because they know in advance that this is the case in the Hanbali school, or this is because we know that in the Mamluki period there were 4 judiciary systems. Okay, so this is another point. That's it.
Thank you very much. In fact, we have to close here, but
no
I
time.
just would like to.
We had one more question.
One more question?
Yeah, one more.
Yes, please.
I came all the way from California, so I'm gonna ask it.
To request an extension of 5 minutes, please. Okay? Yes, please.
They can answer me quickly. So I'm from California. I just flew in from Kuwait. I lead a global studies center there, and I had a conference just last week. It was on the woke movement. It was the second one in the world. The first one got canceled because of the woke people protesting outside. It was well attended. We brought people from Stanford, UC Irvine, et cetera. But why did I come up with that idea? Because this goes into both your points. The scholars, they're talking about how these rights are applied on humans. But a lot of my colleagues, they work in Silicon Valley. Today, ChatGPT released its 4th version. So one of my friends is a CEO. He messaged me, "Oh my God, this is amazing. It's like a human." So we're going now into an era where these rights are going into artificial intelligence, machine learning, right? And in California, we've lost this first principle that you said. Human rights is based on first conceptualizing, right? الحكم على شيء فرع عن تصوره. If you can't imagine a thing, how can we agree what's a woman, what's a man? Unlimited genders. So as we now move into this new era where we can't agree on definitions, I wanted to see how you will answer in a quick. How will these be applied to machine learning? Because the gender transition, that's just the beginning of transhumanism as a larger concept. The gender is just the first aspect.
Thank you. Thank you. Yes, yes, please.
Should I? Assalamu alaikum. My name is Manal Hashmi from Sidra. I'm a genetic researcher. Actually, I would like just to comment and integrating Dr. Masoud and Dr. Mu'taz talk together. It raises a lot of a question in my mind, but I can see that when Dr. Masoud was addressing his part of perspective and his role, it seems to me like the West are considered to be such an autoimmune disease. They are legalizing their own defects, trying to legalize their own defects, which seems to me it's unethic, and accordingly it's really not moral at all. Now, when Dr. Mu'taz have already addressed the precision of fiqh in dealing with the law of right, it seems to me like the physician who really has the medicine to all problems before they rise and while they rise. Now, when you have that problem, and the Western are forming the human rights as an autoimmune disease, and you have the Sharia and Islamic ethic as a solution, they are not coming together, and that's what the politic encapsulates nowadays. So it's just my comment, which raises a lot of a question, and thank you so much, Shukran.
Thank you. Is there any? Yes, please. The last one.
Assalamu alaikum. My name is Merve Özaykal from Turkey. I teach Islamic law and bioethics at Istanbul University. My question is going to be for Dr. Mu'taz. You mentioned about the distinction between Ehliyetul Wujub and Ehliyetul Eda. So, some bioethicists like Singer claims that there's a distinction between person and human being, because for example, if you are in a vegetative stage, so you cannot connect to the other people and you cannot socialize, and you don't have self-awareness, so we cannot call you as a person. Okay, you are a human being. So because of this reason, he claims that we can make euthanasia for this kind of people because they are already not person. So when you mention about distinction between ehliyetul vujub and eda, can we say that this kind of people has ehliyetul vujub but they don't have ehliyetul eda, or do you think that shakhsiyya is different from being a human being? And maybe as a second question, actually I couldn't understand the part of ademiyya. So do they claim that it is a bashar as a human shape? So what is the difference between ademiyya, bashariyya, and insaniyya? This is the second question. Thank you.
Thank you. So I'll just mention about a comment on what Professor Ghali said, and Dr. Mafaz could comment on it, that one of the Muslim modern researcher, in fact, he talked about حقوق الأرض, and he tried to make fatwa about the verse in the Holy Quran, وَلَا تُفْسِدُوا فِي الْأَرْضِ بعد إصلاحها. And this facade, he said that, for example, like what human beings are doing in industrial area where carbon dioxide come from large amount, and then it affects the chemistry of the earth. And this is violate the right of the earth, and that's why it reflects on so it's just an example. So thank you very much, and then back to the speaker. Will start with Professor Mashoud.
Thank you very much. Let me first say that I've really enjoyed this session, and I've also learned from it. I really appreciate, the point made by our sister there about coming together. I think it's really very, very important. And this is why there's a need for, it's negotiation. It's continuing talking. And a lot of the time when I go to Muslim countries, I do argue that they should do more. A lot of the time, people, especially from the Muslim world, as mentioned by Dr. Mustafa, they say human rights is for the West. It's not for the West. Human rights is for everybody, and Muslims should take their position at the table and make contributions and challenge issues. Challenge issues when it comes to the international level. For example, many of the things we're talking about, under international human rights law, there is no treaty recognizing homosexualism. It's just being pushed. Now, if nobody is there to push back, they will push, and it will get there. And we live in the whole world together. Do you get the point? So it's important, that we work together. Now, AI, you did mention, it's very important you mentioned now. The world, I used to say, a lot of the time when we look at fiqh, and when we think that the world is static. The world is not static. The world will continue changing and changing and changing. You talked about the hukuk al-ard, that is the right of the earth. You are talking about, what you have just said, you wouldn't find in any book of fiqh. Do you get the point? If you look in the tafasir of La tufsidu fil ard ba'da islahiha, you will not find this interpretation there in any tafsir. But because of the understanding of how life is going, you are moving it to say that, well, this verse can do this, it can mean this, it can mean that. So AI, we cannot just hand up and say, oh, well, okay, it's just for the West, let them continue. And then at the end of the day, Muslims start to react. We need to be proactive, particularly in relation to human rights, because the world is not going to stop. Things will continue to evolve and evolve and evolve. Our tafsirah should be look ahead, similar to what we are doing now. The world has changed completely. In the next 5 years, 10 years, we'll be talking about something different completely in relation to different parts of life. So the research of Muslim scholars is also to, classical fiqh is very good. It gives us, we look back, but we also need to look forward. You look back, we look forward. So we have to look and see what's going to happen in the next 15 years, 20 years, and how we are going to deal with that based on our fiqh. Rather than saying, well, no, don't trouble it, just leave it. And, it's really important. So thank you so much. I learned a lot. Thank you.
Thank you. As for your question, I think here we have two different concepts before I explain the concept of Adamiyya here. So the first one is pre-personal life, which is related to the philosophical discussion and bioethical discussions also. So they differentiate between what they call pre-personal life and the personhood. So by the pre-personal life, they refer to the controversial issue, which is about abortion, because even, unfortunately, some contemporary muftis, they relied on this concept and they came to the conclusion that, embryo has no value, or at certain stage, or even the, what's so has no value. But this is, in one of my articles that I argued against this conception, because pre-personal life has a value in terms of the concept of Adamiyya. So Adamiyya is related to the embryo, which is in its developing process to be a human, to be a person. So now, at a certain stage, the embryo has, what the Quran called it, مضغة مخلقة وغير مخلقة, So it refers to the concept that the embryo met a certain level of a human body, which has a shape of a human body. Now there's no soul here. The installment is not there, but still, it has a shape of a human body. So as far as it has a shape of a human body, even partially, not fully, a shape of a hand or arm or foot or whatever, so it has it should be respected. It has a dignity. So because it is a developing process to be a person later. So now, as for the ahliyat al-ada, the performance, the ability or the capacity of performing an action or recognized action in terms of morally speaking and legally speaking. So this has two types. Either you perform the action in yourself, directly by yourself, or you are not qualified, or somebody is not qualified to have the independency to act independently, then he needs to have wali. So the wali here in this case plays the role of, filling the gap in the performance, the ahliyat al-ada.
Okay, thank you very much, and thanks for our speakers and for your active participation, and then the poll is for...
Thank you so much. We'll now take a break and we will come back here for session number 2 at 1:30, inshallah. Thank you very much. For the lunch, please. Thank you. Enjoy your lunch. Okay. Okay. Okay, we're starting. Lunch break. We now proceed to the second session of the day, moderated by Dr. Muhammad Ghali, the Acting Director and Professor of Islamic and Biomedical Ethics at the Research Center for Islamic Legislation and Ethics in Hamad bin Khalifa University. Dr. Ghali, the floor is yours.
Assalamu alaikum, everybody. Thank you, Rawan. We have two speakers today. Their background is in law. So I expect that we will see, we will continue in the discussion about the legal and the ethical in the theme of the conference today. So we have two important legal experts. You will see in their, as you can see in the booklet of the conference and their bios, they are both transdisciplinary, engaged with more than one discipline, and also transculture, engaged with more than one country. Dr. Catherine Bailen-Durier, I hope it's the right one. She's in the St. John's University School of Law, and she worked, she has her BA in, she has a BA in political science from Stanford University, GD from Stanford Law School, and MA in Middle Eastern Studies from the American University in Cairo, and PhD in history also from the Stanford University. And she worked in and engaged with different countries like Morocco, Kuwait, South Africa, Egypt, etc. And we have Professor Niaz Shah from the University of Hull. He's Professor of Law. Also, besides his academic work at his own university and engaged with other universities like the University of Cambridge, he also worked with the United Nations High Commissioner for Refugees, Pakistan, Afghanistan, courts in the UK, and so on. So we can rightfully expect a very interesting discussion with the two legal experts. Each of the speakers, as per the schedule, will have 30 minutes, up to 30 minutes, and then we will have the discussion afterwards. I suppose the order will be, we start with Dr. Shah, and then Dr. Duri. Okay, so the floor is yours, Dr. Shah.
Okay, and what about this? If I want to move away from the, can I take this off? Huh? So let's take this off. No, it's fine.
Yeah, you can just do it from here.
Yeah, it just allow. There must be a way. Oh, this is the one. Yeah, this is the one because I do this all the time, and then yeah, let me get control of this. Assalamu alaikum and good afternoon, everyone. As Dr. Ghali said, my name is Niaz Shah and I'm at the University of Hull. In addition to being a professor, I'm also a practicing barrister. I practice law from Nexus Chambers in London and mainly doing asylum and human rights cases. Before I proceed, I really want to thank Samir, Mona, Sarah, the team for making it possible for me to be here after a lot of email exchanges and efforts. And also, we were told that the correct pronunciation is it CILE? CILE. Grateful to CILE to provide the forum for us to talk. I'm not an ethicist. I'm a lawyer, academic and practitioner. So you will see a lot that I'm talking about legal norms. When Samir wrote to me that to tweak it a bit to ethical standards, so I went to some primary sources and picked up some examples which will be a good foundation for Islamic ethics in respect of human rights. What I'm going to talk about is my objectives are really to focus on the foundation of Islamic human rights or the Islamic ethics for human rights and human rights law, and the universality of Islamic human rights ethics. And to illustrate my point, I will just focus on two examples, human equality and dignity, how that is portrayed in the two primary sources, the Quran and Sunnah, and the objectives, what we call the higher purposes and objectives of Islamic law, and what are the objectives and purposes of human rights law, whether they correlate and are compatible to each other. I have chosen the right to life. People who are working in this area, they know that the higher purposes of Islamic law is to protect the right to life, property, progeny, and religion. So this is just, these are the brief points. But I just want to start by, on my aim overall in the larger project that I am doing is to contribute to the reconciliation of Islamic law and human rights standards, to maximize the application of human rights law in Muslim states, which in turn could lead to the greater enjoyment of human rights in Muslim states. There was a question about that, the implementation of human rights in Muslim states. Now, just by way of introduction to my larger project, about 23 years ago, I started working, looking at the relationship of human rights and Islamic law. Initially, I was looking at human rights law, and that brought me to look at the relationship of human rights law with national law, because I was using in my PhD thesis Pakistan as a case study. Now, in Muslim majority states, Islamic law, Sharia, is the primary source of law, so they brought me closer to Sharia law. So in the end, and for all practical purposes, it turned out that I'm looking at the relationship of human rights law with domestic law in countries such as Pakistan, Afghanistan. Now we're moving to Iran and Saudi Arabia as well. But it turned out to be looking at Sharia law and the compatibility. So that's the larger project. Now, Muslim states have contributed to the development of core human rights treaties. But their contribution started before the core human rights treaties. There are about 9 core human rights treaties, dealing with civil, political rights, economic, social, and cultural rights. There's the list, the one dealing on prohibiting discrimination against women, children rights, etc., etc. But they are the core treaties. I don't know why the others are not the core treaty, but Muslims started contributing to the debate. When we trace the origin of modern human rights law, that starts from the UN Charter 1945. There is the obligation to promote and respect human rights. We moved on to the Universal Declaration of Human Rights. If you look at the contribution of Muslim states, it's enormous. There were various blocks. For example, when it came to the freedom of religion. Freedom of religion, when it came to there, Saudi Arabia was against it. Eventually, Pakistani delegation, which led the Muslim bloc. Pakistan was 1 year old in 1945. And at the time that was happening, it was 6-year-old, but the Pakistani envoy was an international lawyer, Zafrullah Khan. He was doing it. He persuaded the Muslim bloc to vote for this. Saudi Arabia, with several other abstains from the Universal Declaration of Human Rights. It came down further down to 1966. We got 2 sister covenants, one related to civil and political rights, the other to economic, social, and cultural rights, and it went on. That was 66, followed by convention prohibiting discrimination against women, and it went on the Torture Convention in 1984. In all this, Muslim states were actively involved in the formation at the formation of treaty. That's the formation stage. And I mentioned in my observation that when it came to 1989, Muslim states were so active that they made kafala included on Article 20, paragraph 3 of the CRC, that's Convention on the Right of Child. They have been active, and they are parties too. Qatar is party to several human rights court treaties, Pakistan is, Saudi Arabia is, Iran is, several other countries. Now, my larger project was that I came across that Muslim states, they enter sweeping and vague reservation to human rights treaties. And the crux of all those reservations is they say they will comply with the treaty provision if those treaty provisions were compatible with Sharia law or the Constitution. They say Constitution, but Constitution is indirectly say Sharia law because the Constitution in most Muslim states, around 46, Sharia is the basis of law. So again, this brings back to the interface or relationship of human rights and Islamic law. And on the screen, you will see I have the Qatar reservation. If you look at Pakistan's reservation, Malaysia, the paper that I have completed, the paper, there are a number others that they have done that. But to that, there is a reaction from non-Muslim state parties. And you can see Sweden as an example to the Qatari reservation, saying such a reservation which do not clearly specify the extent of the derogation raised doubt as to the commitment of the state of Qatar to the objective, to the object and purpose of this covenant. This covenant was International Covenant on Civil and Political Rights, which Qatar is party to. And it happens to several other treaties. Saudi Arabia is notorious. Bangladesh was there, Pakistan was there, several other countries. And so what this brings us to this phenomena that there is this blanket reservation from Muslim states on the one hand, and a reaction, sweeping statements, objection and criticism from other states. And I thought, as a scholar, I said, if there is a proper study, compatibility study of human rights and Sharia law, then that might lead to narrowing down of these reservations. Reservations are allowed by international law to enter into treaties, so Muslim states as sovereign states, they're entitled to enter reservations, but not sweeping and vague. They can identify a provision are to and enter narrow and limited reservations. Similarly, if non-Muslim states, if they have conducted compatibility studies and looked at the Sharia norms, whether they are compatible with human rights, they wouldn't have reacted in the way they did, like Sweden did here. No, in the subconscious, the thinking behind this is that Sharia law is incompatible with Islamic standards, with human rights standards. That's the thinking, and being living in the West, in the Europe for 23 years, I see this every day. I see this reaction from my students, from staff and scholars, and in scholarly works. So this brought me to the point, and I've been looking at this, my own thinking, and in scholarly work, it's not only the state practice. Scholarly works, you will see this, there is a pattern. One pattern is that scholars would say Islamic, there is no human rights in Islamic law. I have seen a newly converted Muslim from Russia when I was a student in Nottingham in 2000, and he came to me, brother, there are no rights in Islam. It's only different. We are slaves. We are slaves to God. That was his concept. And I said, look, human rights are not determined by your relationship to your creator. It's human to human. And you're not my slave, I'm not your slave. Okay? So I said, this is a misconception. To look, I mean, over the years, 23 years, we have heard this all. And then there is another group. For them, the touchstone is for Anwar, Elizabeth Mayer. And when you look at all these people, they look at Reza Afshari, they're looking at it from a secular perspective, and they don't basically accept
that. They say the touchstone is international standards. If anything, they don't conform to this, international standard should prevail. You have another group like Maududi in Pakistan and several other Islamic writers. They say Islam has a full set of rights that's superior. It predates the modern human rights law, and that's the law and it's universal. No, they're coming from the perspective of Islam. Then there are others, reconciliatory approaches. They bring Mashoud Badreen, seeking to reconcile international standards and Islamic standard, An-Naim and myself. So this is the broader context that I have been working, and I started working this in my PhD thesis. I developed this approach, adopted this approach, which over the years has evolved. And the main difference I will show you what in 2006 when I was doing the my PhD, this is my PhD thesis. It was on women's rights, which was published in 2006. I was following this approach of contextual interpretation. My focus again was on Islamic. Those was my early days as a researcher. And I said Islamic law should be interpreted in its proper context, 17th century Arab tribal society and the Quran at that time, and looking at the current situation. And over the centuries, laws interpreted by male interpreters, which led to this gender interpretation of Islamic law. At the time, but my own thinking has evolved, and this was the point you were mentioning, how we started early career research and how the thinking evolved, and now you are expanding or moving away from your original approach. I am not moving away, I'm expanding. At the time, my focus, and this is the main difference between then and now in 2006 on the contextual interpretation, is I now say international human rights law should be also interpreted in its proper context. Look at the formation of international law. Muslim states contributed, but at the time of the adoption of UDHR, 1948, the UN membership was 56. Most of the other countries we see now is 193. They were colonies. The independence, and if you happen to be in the UN General Assembly, and when you look at the world map, there's a nice way. It starts here from smaller, and it goes up. When you keep walking in the corridor, you will see how the map changes. Independence of other states. And human rights contributed to that. But it was predominantly Western. That was mainly influenced. Muslim states contributed that, what I said. But it was predominantly based on the Muslim thoughts. And you pick up any book of human rights when I teach, they say, oh, it was to the great Western philosopher John Locke, you know, and Penn and all this. This is what they did. And no, I challenge that. We are saying, well, every civilization and religion can claim that they made contribution to this. Now that view has been, I think, persuasively and successfully challenged now, including myself and others. So this is the whole idea, that it was Western dominated, and we said, no, we would need now to interpret international human rights law in a Muslim society. So it can be interpreted the right to private life in Europe, which would include homosexuality. But in Pakistan, Nigeria, and Qatar, it can't be interpreted that way, because no treaty, as Mashoud was saying this morning, no treaty would say that it is allowed. But if you look at the wording, it might be. Similarly, prostitution, in this book I was using Article 6 of the CEDA, that's the Convention on Elimination of All Form of Discrimination Against Women. I was looking at that, and Article 6 is about the exploitation of prostitution rather than prostitution per se. And I said, look, if we are doing contextual interpretation in Muslim country, they would say, well, it doesn't allow prostitution. It say the exploitation, which will be perfectly fine for a Muslim state to say, we need to stop the exploitation. So those are just my larger project and context. Then I applied this to my thesis. Then there was some further works I did. I went to the self-defense in this book. Self-defense, what was, you know, jihad, they call it jihad or jihad. Islamic law and international law, I worked on this. I looked at the invasion of Iraq and the declaration of Al-Qaeda. Then I looked at to the Islamic law of Qital, Islamic law and the Islamic law of Qital. I worked in this, and the work continues to goes on. And I reached to a point now when I'm looking at a lot of my PhD students are working and looking at these reservation, vague and blanket reservations and the reaction and objections from other states. I thought it would be good if we can have a framework, how to assess, how to make the compatibility assessment. I was looking at compatibility, where compatibility is defined. In the UK, we have a Human Rights Act 1998, which allows courts to give incompatibility statement to say that a provision of UK law is incompatible with the European Convention, but it doesn't define compatibility. I looked at the dictionary, meaning that means something can coexist without conflict and work together. Interestingly, in Queensland, in Australia, there is an act of a local act of the local body, which says that compatibility means when an act, policy, or practice which doesn't limit a human right, or if it does in a minimum way in a democratic society. So compatibility is tied to this concept of not diluting the substance of a right. The substance of a right, basically. Now, today, coming to today's discussion, to look at the ethical standards. The foundations of Islamic law, international human rights law, is mainly based on three things: human equality and dignity. And in dignity and human freedom, and within dignity, they say another aspect of human dignity is human autonomy. And if you look on the screen, this is what I have gathered from during my research, that this is what it says, but I like mainly the autonomy. Autonomy, which is individual autonomy, which is an aspect of human dignity. The overall objective of this human rights project, human rights law, is a dignified and peaceful life in society. Now, the freedom to live according to one's sense of values, the capacity to enter into agreements, etc., and to make choices. That's the autonomy. Okay? Now, I compare this to the Islamic standards, what we would say ethical norms are legal ethics in the primary source. Colleagues spoke about this morning classical jurists, and then some other jurists, another colleague mentioned, and that's all fine to look at it. Part of my contextual interpretation is that we, people living in this age, in this society, look at the primary sources ourselves. That's not to degrade the centuries-old wisdom or contribution of other scholars, but I said we can look at it. Our mind is not blocked. We can look at it, our own situation, and basically with a fresh eye to these primary sources. Now, coming to the ethical standard, the universality, there was discussion of universality. Mashoud was talking about this morning. In my paper, there's a question, why compatibility? And is compatibility, full compatibility, desirable? Full compatibility is desirable. My central argument since my early days in PhD and the various books that I showed you is that Islamic law is to a greater extent compatible with human rights standards. Further compatibility can be achieved. Further, not full. And I choose these words deliberately. Further compatibility can be achieved, not full compatibility, because my next question is whether full compatibility is desirable. My answer is full compatibility is not desirable and not possible, because the world is not one homogeneous unit. There are a lot of differences, different people. And people have to respond to their local situations and the infinite variety of human beings and individual characteristics. They would have to deal with those issues. So
Doctor, you have 10 minutes.
10 minutes is a lot of time.
Okay.
Thank you. So what happened is that they will have to locate it in the Council of Europe, in Europe, where the convention is operating, the European Convention, and one of the most successful regional human rights system. We say in the UK and the Europe that the system is a victim of its own success. In Europe, we would have thought that it's just one form of Christendom and one geographic unit, similar people. But the European Court of Human Rights says that there is no uniform moral code in Europe, and it has given state parties to the convention flexibility to respond to certain what they call pressing social needs according to their own condition, and it's called the doctrine of margin of appreciation. Masood has worked on that. The margin of appreciation. It's give a little bit of flexibility to member states. So within the Europe, you can't have a uniform moral standard. So what about the globe? The diversity. In Europe, we thought it was a former just, Christendom. Nowadays, things have changed. In the UK, recent survey shows we have more than 50% humanist, collectively called secular atheists. They're just called collectively labeled as humanist, and other people of other religion, including, Christianity, another religion, that's less than 50% in the UK. Go to France, probably the ratio will be higher of the humanists. So different standards. If they can't have a uniformity of moral code in Europe, a small unit, a small geographic unit, it won't be possible in the world. And that's why I say whether full compatibility is desirable. In my view, it's neither desirable nor achievable. We can't be subjected to. But that doesn't mean we don't have consensus on the core elements. And the core elements of human rights, as I said, human dignity, equality, and freedom. And this is what I'm going to compare with Islamic law in the primary sources. And you look at the universality, and I say that the Islamic concept can be better understood in the universality of its message, and obviously I will touch on individual equality, dignity, and the right to life. Islam is, remember, for everyone. And within the Islam, there is a code for Muslims. Even in a Muslim state, Islamic law wouldn't apply to non-Muslims. And that's why, because Islamic law believes on human autonomy, individual autonomy. The religion is for everyone, but in the choice, people have to make choice on individual autonomy. The message is for everyone. There will be people who would accept Islam, became Muslim. There will be people who won't. And that is based on this Quranic verse. This Quranic verse, that there is no compulsion in religion. So people can choose the individual autonomy, one of the foundation of international human rights law. Autonomy, they can choose. But if you look at my definition of the autonomy, which I have gathered through research from different sources, they said to make choices, to enter into agreements. Once you enter into agreement in the UK, in a contract, I have an employment agreement with the University of Hull. So I have a set of general terms of employment and specific core terms of my employment. And my employer and employee are both bound by those. Nobody forced me. There was no compulsion to work for Hull University, like there is no compulsion in Islam, no religion. I chose it They advertised post, I applied for it, we entered into contract and we signed it. That's it. Okay, okay. Right, so we entered into that. Now, for Muslims, those who came and accepted Islam, did a bay'ah, did a covenant with Allah and Muslim, then they had to follow by that code, the code which is contained in Islam for Muslims. That's a covenant. But the autonomy, people say we don't have autonomy. Well, you had autonomy, whether to enter into that covenant or not. Now, I can terminate my contract with Hull University, giving 4-month notice. The question in Islam is whether people can exit Islam, right? Apostasy and the punishment, there is a lot of debate. My early days, my article was on that. An-Naim has written on it. I have written on it. I think Mashoud recently published on blasphemy, so I don't know whether it will be touched or not. But the scholarship, there is a consensus that the punishment they were rewarded in early days, they were for the political crimes at the time of first Caliph Abu Bakr and others. But the debate is going on. People can come on which side they want. Some people can say, no, you can't leave. There will be death sentence. Other will say, no, you can leave. And that's fine, because Yusuf Ali, for example, the Quran translation, the famous one that I'm using here, Hashim Kamali and others, when you say, it's in the nature of religion that you cannot impose it. And everybody's relying on this verse. So there is that debate, and I'm aware of that, but the individual autonomy is there. My view is people can come and go. You can't force somebody to be a Muslim. This new convert Russian guy, he had a Ukrainian girlfriend. That girl was my classmate, and I said, after some time, I met her and said, what happened? She said, we split, and I said, why? He said, the guy was forcing me to become a Muslim. And she was very willing, and she said, let me read the Quran, let me just understand it, let me settle down so I can become a Muslim by heart. But he was pushing, no, just come to mosque, say, Kalma la ilaha illallah Muhammadur Rasulullah. But that's in the nature of things, separate debate, but I think my point was the individual autonomy, and I think I have beaten that. Now, human equality, another foundation of international and Islamic law. Very clear verses of the Quran. People are created from a single pair, and they're equal, and they have been distributed in nations and tribes, so that they know each other. These are the words of the Quran, not to hate each other. And there are a number of large, when we talk about equality, equality is just another kind of another aspect of non-discrimination. Non-discrimination, we have a number of examples in the Quran, how discrimination was prohibited at the time of Prophet Muhammad. I have a good example from second Caliph Umar, but I'm going to just conscious of time. Now, interestingly, building just on that point and looking at the Quranic evidence.
Doctor?
Yeah.
You have like 1-2 minutes.
Okay, okay.
So
looking at the evidence in the Quran, recently I found that the Quran tells the whole humankind ummah. And within the ummah, there is a Muslim ummah. The Muslim ummah come from the hadith. I'm still on the equality of, this is the universal message of Islam. And look at the words that I've cited, which is say, the whole world is one ummah. And then within that, there is a Muslim ummah. So human equality is there. That foundation is compatible with international standard. And I think the right to life, we have just covered this. This is a well-known verse of the Quran. If you slay a person, innocent person, that is if you have slayed the whole mankind, and if you save a life, as if you have saved the mankind. Obviously, there are a couple of grounds on which life can be taken away. But Allah says life is sacred, and Allah can give and take life. And this is the higher objective. You know, objectives of Sharia, to protect life, progeny, wealth, and property. And that's my conclusion. My conclusion is that if you look at the foundations and the higher objectives of Islamic law and compare it with international human rights standards, you will see greater compatibility. On these 3 points, there is full compatibility. When you come further down to other rules, there might be variation. And I don't mind Muslim states entering specific reservation to treaties. It's allowed by law, and as a sovereign states, they have the right to do that. I will stop here, and I will be happy to respond to questions.
Thank you so much. Thank you. We move now to the second lecture, Dr. Dourier, and we will have the discussion after the 2 lectures. So please, the floor is yours.
Thank you so much. Let me just set up my timer.
Okay.
Maybe make your job easy, I hope.
Okay, thank you.
Go. Okay. Yes, thank you so much. Thank you to Dr. Samer, to everyone at CILE for putting on this already very rewarding and I think very rich and extremely well-run conference. I also want to thank our simultaneous translators. I know that's very hard work and really appreciate making the conference accessible to everyone. So thank you so much. So I'm also a lawyer and coming at this from a perspective of focusing on law and legal frameworks. And what I'm going to hope to do in a presentation is talk a little bit about some of the presumptions that I found in reading the scholarship coming from the legal perspective on human rights and Islamic law, and particularly, I'm a legal historian, so particularly looking at the historical literature, referencing a lot of the same literature that you just spoke about, so that was such a lovely introduction to what I plan to speak about today. And then dig a little bit into my research into the early practices of some Arab human rights NGOs. And then I swear, in the end, I'm going to come back to how this all relates to these questions of Islamic ethics and tie everything together. So what I've noticed in the literatures that I have read, particularly in legal history and in law, focusing on this issue, is that I sort of saw 2 trends, both of which we've heard a little bit already today. So one is the trend of sort of evaluating, okay, what is the content of Islamic law? What is the content of human rights law? And then where can we find compatibility, right? Where can we sort of find common ground? I think there's a lot of rich scholarship in that tradition. And then there's a trend, is particularly in historical literature, to look back at the origins of human rights law and sort of recover their more global roots. And so this is a lot of the work about looking at the drafters, for instance, of the UDHR and uncovering the work of Chinese delegates and Lebanese and Indian, looking more specifically at states' contributions to other treaties to kind of push back against the narrative that they came purely from the West. And as you said, I think that narrative has been pretty well debunked, and we have this really rich historical literature now on the contributions of different states. And both of those literatures, I think I see threads of some common assumptions. And one of them is that these bodies of law, although to be honest, I'm speaking with more authority on human rights law because that's actually my expertise, not Islamic law at all, but this supposition that human rights law is static, that it is fixed, that we're looking at the content of the treaties to determine what we're talking about when we talk about human rights law. And that's sort of juxtaposed against a fixed notion of Islamic law with particular sources, and that those sources can be compared. And the other assumption that I came across is that both of those worldviews provide a complete, or I should say both of those perspectives provide a complete worldview. So in the human rights literature, we see this in the work of Sam Moyn and many others, that human rights are kind of this holistic worldview. And my research into how human rights activists actually practice human rights, kind of on the grassroots NGO level, I think challenges that last assumption, which is the idea that human rights provide this complete holistic perspective, a holistic political perspective, a holistic ethical perspective that sort of encompasses everything and doesn't leave space for other perspectives to be taken into account. And what I found instead was that when considered in a comparative lens, in a comparative historical lens, I saw the practice of human rights as being dynamic, constantly in flux, not fixed at all, and also allowing room for sort of ethical and political pluralism. Okay, so like practically what that meant is I spent some time researching and talking to early activists in Morocco, in Kuwait, in Palestine, a little bit in Egypt, sitting down with people in their offices, in their homes, in coffee shops, and talking about their work in human rights, mostly from the late 70s to the early 90s. Although some of which I'm going to talk about today is a little more current, but that's the period I'm really focusing on, because that's often sort of held up as this golden age of human rights activism, where there was a huge proliferation of NGOs and a really strong development of the international community in human rights. And what I found across these different NGOs is that they used human rights to advance different worldviews and different political philosophies. So I'll get into the details of what they are in a moment. But I want to say from the outset, this is not to suggest that somehow their commitment to human rights was any less valid. That's often a critique that is lodged against human rights activists, like, oh, you're just being political, or this is just politics by another name. And I just want to say that's not at all what I'm saying, but that they had different pre-commitments and different ideological perspectives that shaped what human rights came to mean for them, in the way that they organized, in which human rights they prioritized, and that there was space within that kind of human rights framework to accommodate these different political perspectives. And so the big conclusion that I drew from that was that human rights, when considered on a grassroots level, can be consistent, or is consistent, with a number of different political persuasions, some of which might be considered to be contradictory with some aspects of human rights law. And no one sat down with sort of the foundational texts, say, of like Arab nationalism or Palestinian nationalism or socialism, and did like a line-by-line comparison to see if there was perfect compatibility between them. But in the lived reality of these activists, they found that the two frameworks work together. Okay, with that, let me dig into get a little bit more specific. So one of the organizations that I looked at was a Palestinian NGO called Al-Haq, which is now quite well known, but in 1979 was just sort of an idea of a couple of Palestinian activists, all of whom had been educated abroad. So it was two lawyers and one non-attorney who were educated in the US or the UK, but had come back to Palestine and brought a human rights frame with them. And for these early activists, they were very clear that human rights activism was a form of Palestinian nationalism. They used human rights to create a different view of, or a different way to approach Palestinian statehood and Palestinian nationhood. And they embraced human rights because it put them on the same playing field as Israelis. They were able to make claims that were understood internationally, and that they felt gave them access to a kind of credibility that they felt Palestinians otherwise didn't have on kind of internationally. So that was one way for them of approaching this goal, the overarching goal of achieving independence and statehood. And one of the many reasons that rights appealed to them was because the way that human rights documentation could be used as a form of collective memory. And you talked to them about how setting down and creating this historical record was really important, and that rights language was one way to do that. And so it wasn't just sort of the content of the treaties that they're talking about, but they're actually talking about the practice of human rights, of documentation, of what it means to make a human rights report and to have that record of kind of the lived experience of being a Palestinian living under occupation. They did all kinds of other things that we think of when we think of human rights activism. They pursued strategic litigation and brought lawsuits. They represented individual clients. They published Know Your Rights pamphlets. They did public education, right? All things that we associate with human rights activism now, but were still tactics and strategies that we're developing, some of which were new or being reimagined in new ways in the late 70s and into the 80s. But what I think is a really important point to take away from the conversation today was that their understanding of rights was not a retreat from nationalism or not a retreat from a more political version of nationalism, but simply a different way of articulating it. They really believed in the early days, many of these people are now much more cynical, of course, but believed in the early days that international law and human rights was a way to kind of force the international community and force Israelis to recognize what was happening and change the political facts on the ground. Of course, my phone went to sleep, and now I can't actually see the timer. Wonderful. Okay, and so you can imagine how Palestinian nationalism was understood and defined in the 70s. Not necessarily completely compatible with the norms of international human rights law. But here were a group of activists who, through their daily work, through wrestling with the treaties and wrestling with their lived experience of being Palestinian, created an ideological understanding of human rights law and Palestinian nationalism that were not just compatible, but reinforcing tools. I should note, and I will come back to this later, but the founders of the organization, the 3 founders, were Christian Palestinians, although the vast majority of people who have worked at Al-Haq over the last couple of decades were not. But that's relevant in terms of the concept of thinking about how these interact with Islamic and other ethical views. The same year that Al-Haq was founded, 1979, we also had the founding of a wildly different organization in Morocco called AMDH, which was a sort of vast, sprawling political movement that was avowedly socialist and that mobilized tens of thousands of Moroccan volunteers, students, members of political parties into kind of a network of people who supported human rights. And again, you had people coming out of a particular ideological tradition that wasn't partisan, so it wasn't political in the sort of capital P sense of the word political, but nevertheless kind of some shared ideological foundations because of a commitment to sort of radical leftist groups and socialist groups in Morocco. And their commitment to this belief in sort of mass organizing, deeply rooted in their commitment to socialism, influenced the way that they practiced human rights, which ended up being very different from how it was practiced in Palestine. So a lot more focus on mass education, on mass organizing, on sort of human rights practice as protest in and of itself. And I don't want to say that they didn't document human rights abuses, they did, but much less focus on this kind of elite, high-level documentation of human rights abuses, and much more focus on sort of mobilizing people as part of a commitment to mass action. And one thing that I found really interesting about the group in Morocco is that I think, at least coming from an American perspective, you might expect that the organization would focus more on social economic rights because they were a socialist organization, but they didn't. They also started with political and civil rights because the organization grew out of communities that were imprisoned, and their sort of initial primary commitment was to ensuring that civil and political rights were respected. So that brings me to the third organization that I want to mention today, which was the Arab Organization for Human Rights, which was is a regional network of human rights organizations that grew out of a meeting that happened in 1983 and then some subsequent organizational meetings that were primarily attended by Arab nationalists who were kind of organizing in the wake of the 1967 war and kind of reimagining what Arab nationalism could be, and focused onto human rights as a framework for organizing for change within sort of the Arab region. But because they were committed to transnational Arab community building, the way that they did that was quite different from the other human rights organizations, right? There was a regional approach that focused on building Arab unity and focusing not just on the conditions in one country, but on thinking about human rights and political identity in the region as a whole. So I've just briefly talked about 3 organizations that had a lot in common, right? They all identified as human rights organizations explicitly. They all led with their commitment to human rights and international law. They all did documentation, some kinds of public consciousness raising. They all participated in various ways in the international human rights system. But they also did things quite differently because of their sort of political pre-commitments. So you had, in Palestine, a real focus on establishing legitimacy and credibility internationally, because there was a big focus on getting credibility for the Palestinian national movement, and they thought that was the most effective way to do that. In Morocco, you saw a focus on mass organizing, mass protest, built consciousness raising, and a lot of sort of bottom-up organizing. And in the AOHR, the Arab Organization for Human Rights, and their sort of individual chapters, there was much more focus on building ties between different Arab countries and advancing kind of an idea of Arab nationalism that wasn't reliant on political unity after the sort of wake of the failures of some of those movements. So that was some lovely stories about Arab human rights NGOs. But what does that sort of mean in a context of thinking about Islamic ethics and human rights and trying to move past some of these conversations about compatibility or not compatibility? Well, human rights activists generally, especially in this era, did not work with Islamic activists, did not engage a lot with political Islam, except kind of as seeing them as political antagonists. And I think that antagonism was often encouraged by the states, by state governments, hoping to pit different opposition movements off of one another by strategically supporting certain groups. And in some cases, it was even controversial within those human rights organizations to advocate for the rights of Islamists. So particularly in Egypt, there was a lot of debate initially over whether to even advocate for the rights of Islamists who were, wrongfully detained or detained without due process or tortured. And so I think that framework raises some interesting questions about why. And I don't think that anyone would say the why comes down to sort of the incompatibility between texts. And my research into these NGOs and their political commitments to me highlights that like I said, no one was sitting down with the text of Islamic human rights law and, the core beliefs of Palestinian nationalism or socialism and trying to justify their work by comparing them. No, that's just not how they approached it. What that is often sort of how we approach the compatibility between human rights and Islamic law, because they've been set up in this kind of oppositional framework. And, there are certain areas, Dr. Mashoud mentioned several of them earlier today, right? Torture, due process, areas where it's not really, I don't think there's much controversy over whether there's substantive overlap, right? Presumably there would have clearly been substantive overlap between the commitments of human rights activists against torture and the commitments of within Islam that are against torture. But nevertheless, we still see these movements set apart, not just conceptually, but also politically. And the intervention that I'm hoping to make in this paper and kind of in my broader work is that, yes, human rights are legal texts, but they're social and political processes. They're constantly made and remade through social practice. And if we view human rights in that lens, then it allows space. It allows space for ethical and political pluralism. And I would argue that's not just a philosophical point that I'm making, but actually a historical reality, that there was space within human rights activism, in at least these 3 contexts that I've talked about. I would imagine you'd find many more, for pluralism of belief. Now, if you look at just one NGO, or if you talk to the members of just one NGO, you might not see a lot of pluralism, because there was I think often a lot of homogeneity, and when you had a different NGO, maybe with different whose members had different political beliefs, right? They might form their own organization. So it's really this kind of comparative regional perspective where you see space for quite a number of different interpretations of human rights and how they intersect with different ethical and political beliefs. So that is what I think, I told you I promised I would bring this back to questions of Islamic ethics, about which I am in no way an expert. But where I do have some expertise is in this idea of human rights practice and what kind of space it leaves for other ethical visions. And in the call for papers and in other similar academic projects that I think have happened recently, there's been a lot of talk of sort of like clearing ground and thinking of new ways of approaching this issue. And I think that there's a lot to be learned from an intersection of historical inquiry that really digs into human rights as social practice and some of the more theoretical questions that many of the other speakers are talking about today, and how we think about whether there is space. And I will leave it to others to talk about whether there is space in the realm of kind of Islamic ethics, but I can say that in the realm of the practice of human rights, I think we've seen that there is space, and that how that space is framed is often very politically constituted, and sometimes coming very top down from states. And you see people reacting to state pressure to try to divide social movements and oppositional movements in particular ways, and recognizing, like as you said, recognizing that the treaties are products of particular contexts, recognizing that that division is in many ways also the product of a particular political context, and that those different systems of ethics might intersect with one another. So I think I will end there, hoping to leave a lot of time for questions and interaction.
Thank you. Thank you so much for both speakers. Now we open the floor for questions. I myself have a couple, but I would like to start with the colleagues who have any questions. Yes, please.
Thank you very much for those two presentations.
Just a second until we get the mic so that we can have the translation. Usually there is a button there when you press it. Yeah? Okay. Try now. Yes,
great.
You are live now.
That's technology.
Yes.
Yeah. I mean, I said thank you so much. For the two presenters. The benefit of this type of meetings is you continue to learn. So I have two questions, one for Niaz and the other for Catherine. The first one for Niaz. I mean, one thing I've been struggling with is you did mention that human dignity, the concept of human dignity, is universal. Now I've been struggling with it, and I've raised this question, and I hope perhaps maybe if you can share your view. Is there really a universal concept of human dignity in that text? And I'll give you one example, and this one example, particular also in relation to ethics. And I mean, this is just the example that comes to my mind immediately. Look, for example, in the Quran, women's dress, wearing the hijab or niqab. You find it in the Quran. And the ethical reason for it is indicated. If you look in Quran chapter 33, verse 50, he said they should cover themselves like this so that they may be known and not be harmed. It's about protecting the dignity of that they will not be troubled. This is what the Quran says. But in the West, you find a lot of argument. I mean, they don't see it as dignity. Do you get the point? You see that, well, it's not dignity. Women who dress, they are oppressed. So if there was a general concept of dignity, the Muslim woman dresses this way voluntarily to protect her dignity. But in the West, I mean, so this is the point I hope you can clarify for us. Catherine, thank you so much for your own presentation as well. I mean, and the work you do in the field, particularly. I guess maybe, Al-Haq, Lynn Welshman has published, a book on it recently about their history in that regard. And many of the points you raised, she also raised in it. But what I'm really interested in a little bit of clarity, you're talking about legal pluralism, that perhaps, pluralism, but then the literature indicates, pluralism itself, and I'm just trying to problematize these issues so that you can dig deeper into it. When we talk about legal pluralism, the literature informs us that, legal pluralism can be harmonistic pluralism, whereby different systems of law exist side by side. They coexist. They don't trouble one another. I believe that, but that's not always the case. Sometimes you have also a nihilistic or some adversarial pluralism, where one system wants to shut down the other. Do you get the point? It's pluralism. They are all existing, but, they want to shut down one another. Therefore, my point is, do you foresee, in trying to, the relationship between, Islamic ethics, Islamic human rights law, and conventional human rights law, do you foresee a harmonistic pluralism? Or perhaps, it's going to be nihilistic? Can they really coexist in that perspective? Thank you.
Other questions? Dr. Mu'taz? No?
I just wanted to say that anybody can just click on the button, on the right button, and then he can speak without needing the mic.
Okay. So you could prove this. We now see that it can happen. Thank you. Any other questions? Okay, so we can start with answering the two questions and then we continue.
Okay, there you go. Yeah, okay, that's fine, thank you. Mashoud, did you say that in the Quran it says hijab and cover themselves? Is it in the Quran? Yes. Okay. 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 So what it? Okay. Okay.
By the way, just to make it clear that this would mean the hijab that we have now is matter of debate, but we have a discussion.
Okay. Yeah.
Not to mention that ذلك أن يعرفنا فلا أزينا is an interpretation of human dignity. There is another debate. At least from your perspective.
Okay. Yeah. I would just say about the parda, the concept, because I was looking at it before, and the two verses I found is just the same for men and women, the same, to cover your bosom and keep your gazes lower. That's just for both. There was no difference. Yeah. My point, Mashoud, was in general about the message, the universality, the universal message of Islam, which is addressed to Ya Ayyuhan Nas rather than Mu'mineen, to Muslims and to others. And then within that broad message, there is a code for Muslims, which they need to follow. And obviously, the concept of dignity I was explaining, that's the Islamic concept of dignity. I think I just displayed the slide, but did not go through the verses. The verses were there, kind of the paraphrase of those verses were there for reference. But if you look at the from the start, to say that God has created man, it's after that it goes, it's in the best shape. Then it has given knowledge, reason, preferred over angels, and then has created everything in the universe for the benefit of men. Man has been made vicegerent on earth. And the point which you touched on this morning is that initially in my early days as a researcher, I thought it was a Christian concept. But recently I found evidence in the Quran is that God has blown His Spirit into man. And I thought initially it was Christian, but it might be continuation of the Abrahamic religions. That to look at it, that man is dignified because God made man in His own image, which is Christian line. But here, this was recently I discovered, and that's why I put it in the PowerPoint, it's in the paper, to say, okay, so it seems to be the same or continuation of the same thinking. And that's where the dignity was coming. But that is within the message of Islam. It's the Islamic concept rather than the universal concept. Islam is for everyone, and when they come and look at it, that will be the dignity like we have for seculars. And in my PhD days, I had a friend from New York. She was atheist, and she would be challenging me all the time. She was a good friend. And we talked about, she mentioned just over a coffee about the old profession in the world, prostitution, and then I said something, well, old but probably not dignified. And she was working on this cobweb theory. She was a big theorist and herself confused and would immediately confuse others as well. That was her specialty. But she said, what is dignity? Why you say it's not dignified? And me, a young guy coming, in those days young, coming from a Muslim country, born and brought up in Pakistan and educated and mind filled with all these traditional things, a lot of which don't make any sense, are too remote from even Islam or Islamic sources. So my head filled with that, and I said, well, it's not dignified. She said, what is dignity? Tell me dignity. What is dignified? You know, so I think the concept is different. Overall, my point in this paper is, and still working on it, is that if you were to look for functional compatibility, whether both can come and one is not ousting the other, this is what I'm defined compatibility, then I say there is a greater, and I said I use the word deliberately, greater rather than full compatibility. They can work and sit, and I said full compatibility is not desirable. So if there is a difference between the Islamic concept of dignity and a Western or other, then for the Muslim world, the Islamic concept is good enough. And if they were to enter reservations, they don't need to, probably to skip. So there is a foundational compatibility, and it will be always like this. The hijab and the thing you mentioned, in the West, we both live there. People think it's oppression. Even the European Court of Human Rights is thinking about this. They give more importance to Christian, their own religion, which was for some and still is, but not to Islam. When it's come to Islam, the criticism is very different, and it excludes, and the way it deals the Turkish cases and the Islamic parties and various things, it's definitely biased the European Court of Human Rights. I praised it. It's one of the most effective regional systems, but this is the view. It will be there for me to look how they can sit together and work together. You don't need 100% compatibility. Things need to fit in. That's not even desirable. So that is my main point that we need to come to end this. And this is my favorite quote from Dina Shelton, an American professor. And when I teach human rights, we talk about the infinite variety and characteristics of individuals. And that is the richness of human rights. Interestingly, if you look at human rights law is really great. Human rights law accommodates all these things. It's not. Imagine this, it gives the state parties to enter reservation. What if they were not? What if they were not? They want to bring people, they give you this window. The whole concept of human rights, internationalized based on the sovereign states. States has the autonomy. They voluntarily enter to abide by that agreement, those treaties. Nobody's forcing them. Nobody forced Qatar to go and sign a treaty, or Pakistan or Nigeria. This is what they do. So I'm just saying this is work, and when you see this various ethical standards, they converge. They more converge rather than diverge. But when you look at the practices, this morning there was a question about the law, why Muslim states implementation and commitment. I say they don't implement their own laws. Rule of law. Is the judiciary independent in Nigeria, in Pakistan, in other countries? Go there. Is the judiciary? It's not. And that's more related to our institution, our democratic setups to uphold these human rights standards. Yeah.
Thank you. Catherine.
Thank you for your very thought-provoking questions. So first, you raised an interesting question about legal pluralism. So I'm going to make one point about legal pluralism, which is to say that I think we all live in legally pluralistic societies in different ways, right? So whether that's just national and international law intersecting with religious law. If you're American, you have local, state, and national, federal law and international law and various religious approaches to law. And in any of those systems, there's incompatibilities. And yet we don't think of the system as being sort of impossible to function, right? So again, in the US context, right now we have massive disputes over abortion or over legalization of marijuana. We have contradictions within our legal system because we have a pluralistic legal system. And maybe that's not ideal, but it's still functioning. And so I think the idea that these are fitting into, like, that we can have a legally pluralist society with systems of law that aren't perfectly compatible is not revolutionary. I think that's actually just describing how we all live. But I'm not sure I would say I'm really talking about legal pluralism so much as ethical or political pluralism. And I thought a lot, my title for the paper, the working title, let's say, uses the phrase ethical pluralism. I'm not sure that's actually where I'm going to land, because I don't think that these people are actually talking so much about systems of ethics as they are about political ideologies, which of course implicate ethics. And I'm still thinking about how those intersect with each other. But I don't think that they're really talking about legal pluralism. I think they're talking about a broader, let's say, ideology within these human rights movements for that kind of pluralism. Now, what about where one system wants to shut down the other? I think that there's a couple ways of answering that. One is to draw on some of your own remarks from this morning, which is to say that mostly that's not in fact what's happening. That actually, right, it's not as if you have Muslim majority countries and, on the one hand, and then sort of human rights countries on the other hand, right? Almost or pretty much every country has espoused human rights values to a certain extent, and then countries have also adopted other sets of values to certain extents, and so everyone's trying to figure out how we navigate both of those systems interacting with each other rather than shutting them down. Now, if you're talking about many of the people who I interviewed would say political Islamists are trying to shut us down, and I would imagine that perhaps the other side saying, well, human rights activists are trying to get rid of Islamic law. So I think there are people who might see it as a more oppositional framework. And the way that I, as a historian, maybe it's a little bit of a cop-out, but I would say you try to understand the politics of that. Why is it framed that way? Why do those people understand their positionality such that if the other ideology is allowed to be freely expressed and part of the political discourse, then their ideology will not be? And I think that that's very historically and politically contextual rather than an inherent feature of human rights law. And to your last question, do I foresee a harmonistic plurality developing? I mean, I think to do the work that most of us do, one has to say that things can get, that we can move towards a world where there is more harmony. But I would say I don't see that at the level of kind of theory and textual compatibility. But I see that all the time when I look at actual human rights movements on the ground, at the level of national NGOs, at the level of social practice. I see harmony all the time. And to give just one example, when I was in Morocco, many of the people that, so I was just like sitting in the NGO's office doing research, digging around in their library, and many of the people who were working and volunteering there were fasting for Ramadan as they advocated for the right for people to eat in public in Morocco during Ramadan. So obviously and I wasn't interrogating them about like, so exactly how does that work for you theologically? That wasn't my research question, but I just saw that practically for them, these things were compatible and that they had worked out a way that for their understanding of their own religious practice and human rights, that was in harmony. And so I think that that's already happening all over the place, all the time, in different contexts, in different ways, even if it's not happening sort of from the top down. Thank you.
Thank you so much. Yes, please, Dr. Samer.
Just press a button. We are told press a button.
Yes.
Well, yeah, thank you very much for very interesting presentations. I'm trying to combine what I've heard in the first session and this session, and apparently Dr. Shah and Dr. Badrine agrees that, kind of sweeping reservations is unjustified. If any country has the right to put some reservations on human rights, then they need to offer a kind of valid justifications, ethical justifications, and I think Dr. Mashoud gave us some examples on this. But apart from this, you are talking about a sovereign state. Well, I mean, basically this is okay, but what we see in many Muslim countries, at least in our context, to which extent they represent the tradition that they are defending. In another way, I mean, this is basic or how to say primary observation that Islamic declarations, Arabic declarations were supported somehow by national states. I mean, basically not Islamic states, national systems, maybe in a way to liquidate human rights, because they don't abide by human rights anyway in most Muslim countries. So they support initiatives to make Arabic declaration of human rights, Islamic declarations for human rights. It seems that what they want to say, well, we are a little bit different, so don't criticize us too much. But maybe, I mean, in your presentation, what you are saying, well, Muslims, I mean, practitioners, they don't see much conflict between like the basics of human rights and their own identity or religion. It's a kind of made up conflict between two systems, I mean, in general. So, yeah, my question has to do with, do we have like, studies about the concept of sovereign state and how they decide, how they put their reservations, to which, I mean, background, I mean, we have, I mean, states have representatives, but these representatives, what they represent, Islamic tradition, Arabic tradition, for example, I mean, national, it's not clear, actually. I mean, there's much politics than law or ethics, as far as I can see here. Well, yeah, basically it's and the question is, what kind of moral justifications that can we offer for our reservations on some of, if there is any, like human rights laws that we can, like, we have reservations on? What kind of are there a kind of valid moral justifications against them? How would you imagine such kind of justifications?
Thank you so much. If you could please provide B.
Thank you, Sami. That's actually some very good observations, and I'm going to respond to. But hopefully it will provide further clarity. In Muslim worlds overall, there is a, let's say, to put it mildly, poor understanding of international law and how international law operates. I just did a piece published last year on application of human rights treaties in Muslim states, the practice of Pakistan. I trained a lot of judges on human rights from Pakistan, and they just sit there and they say, sir, we are not with you. They just don't want human rights law. And people I trained, they went back and I say, have you written any human rights judgment? They say, I haven't got a human rights case. No, a judge sitting in a court from morning till evening, some go home early, but their job is basically fundamental rights. So they deal with murder case, that's the right to life. They deal with assault. They deal with irrigation case, there is a fight. The right to property, there is a dispute on a plot, flat, that's the right to housing. I keep telling them it's all there, and I say human rights lies there. The right to bail, that's the right to liberty. I say, how many bail application you had? They say 20. I said, you had 20 human rights cases before you today, and you say you don't have a human rights case. So there is this poverty, intellectual poverty, about this. The way, and it's common feature, you guys recently started this, go to other countries, Kuwait is doing something, they invite several, they're just coming up slowly with this. And I don't say there will be good judges or good individuals who will have a good understanding of international. I mean, the way international legal order operates and international law operates in states. And the international legal order, states are sovereign entities. State sovereignty, that's a big hurdle to the application of human rights law. State can voluntarily choose which treaty to sign. This is how I start. This is how the framework operates. For human rights treaties, in the Vienna Convention on the Law of Treaties 1969, there is just only one bar for reservation. That is, you cannot enter a reservation, a state cannot enter a reservation which will be against the object and purpose of a treaty. And this is what Sweden was saying against Qatar. Then each treaty will have some specific provisions on reservation, which treaty you cannot enter reservation to or derogate from in time of national emergencies. There are some basic core rights called just cogents. They cannot be suspended in national emergencies. They cannot be entered reservations to. A number of provisions will be there in treaties. Now, so that's how the system operates. This is how the system operates. From the international law perspective, they have given this window to states because they want maximum people, diversity of culture in states, region to come on board into the human rights fold and be party to that. Justification. This is my whole presentation on this, that the moral justification we want. Catherine talked about, this politics about our politically constituted groups and oppositions, and from one time to another, how things varies. For example, today in Afghanistan, there are Taliban. They don't accept all the treaties and look at what they do on women's rights. But before that, in 2004, we had Hamid Karzai, American-backed guy, Americans, several other countries, NATO countries were there, ISAF, International Assistance Force were there. They had in 2004 a good constitution. There is a decent chapter on human rights. And immediately after that, when Karzai was installed, they say democratically elected, but the whole democratic process was managed. Afghanistan, under his leadership, became state party to CIDA. That's the Convention on the Elimination of All Forms of Discrimination Against Women, 1979, without reservation. I was in New York in UN working with CIDA committee, the only male in the entire female section. And we were just clapping hands, without reservation. And I said, it won't work. my boss and everybody wanted to throw me out. They say, I say, look, the practicality of this is, when Muslim states enter reservations, we battle it at the UN floor. This is right, we enter criticism, objection by the state parties. If it's smooth, the debate will move on to the Supreme Court in Afghanistan, because Supreme Court was the final arbiter to look at it. I say the forum for debate has changed. The court may declare that certain provisions are incompatible with Sharia. In the constitution in Afghanistan, Sharia is the source of law. The same was with new Iraqi constitution, new Somali constitution. I worked for the UN in Somalia. We were facing the same problem. So it depends on, so they need to be, my whole point is, even if you have a ruler pro-West or installed by the West and say yes, issue a presidential decree to say we agreed it. When it's come to court and interpretation, there will be issues, and then courts will be looking at it. In the UK, the Supreme Court and higher courts can give incompatibility statement that a UK law, primary or secondary law, is incompatible with the European Convention. They can do, so I say it will go there. What I say in the framework is this. So the political thing is, it depends who is ruling the country, who is in the government. Liberal Party or a Jamaat Islami or an Islamic party, how they go. In international legal order, states are represented by state representatives. So they go and sign. The foreign ministry will go and sign it on behalf of the state, and there will be internal process. So that's about the process. Now, moral justification, my whole point is that, look, there is greater compatibility than people think. There are more common grounds. Further can be achieved through a careful study and contextual interpretation. We would need to interpret Islamic law differently these days. We will be needing to move similarly human rights, and there will be greater, and that's their moral justification is Sharia. And then you say what? Mashoud was talking about which interpretation of Sharia, and this is the diversity. I say compatibility is not possible. The world is, there will be secularist religion, then in religion you got several religions, and then in one religion you got several sub-religions and interpretation and sects. So it never ends, and that's why I said we would need to be specific. For practical purposes, and as a lawyer, I want a framework to look at it, identify chapter and verse which would conflict, which would not, or enter what they call interpretive declarations. This is how we would interpret. Qatar reservation is actually interpretive declaration, that how Qatar would interpret punishments. Because I can see what Qatar representative were thinking. They were thinking of Islamic penal laws, the sanctions, hands, hang. Happening here. I'm not saying it's happening in Qatar, but what I'm saying is, and it could be just state parties are trying to be safe. They give them the strategic. They say, let's enter this, and then we will come to interpretation later on, and we will see which suits them. They will adopt that one. Yeah.
Okay. Thank you. Kathy.
Yeah. Let me just speak to one piece of what you said, which is the conflict between human rights and Islamic law real? And I think that it's an interesting question, because obviously there are points of conflict between any two legal systems. But I think what your question raises is, why is this the way that the conflict is framed? And I think a lot of that is rooted in colonialism, in post-colonial understandings of law and transfers of law. In the most sort of contemporary sense, I think in the United States, there's a whole discourse just since 9/11, right? There's a huge focus and lots of money on thinking about Islamic law and human rights law, and are they compatible? And I think that from my understanding of that question, it really comes down to, of course, there are real differences and different understandings and frameworks, but what's interesting as a historian to try to understand is how are those real differences politically constituted into sort of a whole discourse, and why is it not discourses about human rights law and French law, and human rights law and American law, and why is this opposition set up in the way that it is? And I think understanding and talking more about the political reasons for why the opposition is set up that way clears ground to talk about, well, how do we actually move forward from that with a better historical understanding of how we got to where we are? Thanks.
Yeah.
So much. Very quick.
Very quick.
Concluding
Yeah.
remark.
Whether it's real, whether the conflict is between Islamic law and human rights law is real or not. The conflict between Islamic law and human rights law is as real as is a conflict between English law and human rights, French law and human rights, and American law and human rights. If you look at the reservation of the UK, it has entered to several treaties. The United States has not even ratified most human rights treaties. They don't care, okay? But they do reports on the whole world using those standards which they haven't ratified. This is the hypocrisy of them. But if you look at the French, the Spanish reservations to human rights treaties, to refugee, I was teaching on Monday Refugee Convention. It says UK went chapter by chapter, article by article. This is what we want to. These are our reservations. This is how we will declare. Now, other states know where they stand in relation to the UK with them under the obligation for the treaty. With Muslim states, it's just there, one line, compliance with Sharia and our constitution, and that's it. And everybody say, hang on a minute, what does they mean? And especially if they think Sharia is against Islam. Thank you.
Thank you so much. Thanks for both speakers, and thanks for those who engaged with it. And I give the floor to Rawan. Thank you so much.
Thank you very much. That was very thoughtful. We'll now have a coffee break. We also have some refreshments. Please enjoy your time, and we will come back here at 3:30, inshallah. Thank you. Welcome back. We hope that you found the discussions very useful and enjoyable. We'd appreciate if you share your thoughts on our website and social media using the hashtag CILE2023. We're moving forward now to the last session of the day, moderated by Dr. Ahmed Aysan. Dr. Ahmed Aysan is a professor of Islamic finance and economy, and he's also the program coordinator of our PhD and master's programs in the Islamic finance at the College of Islamic Studies. Dr. Ahmed, the floor is yours. Thank you.
Thank you very much. It's my great pleasure to moderate this session and with very interesting papers and speakers. We have about an hour. We are a bit over time in terms of starting, so we have about 50 minutes. It means that we have like 25 minutes for each, and probably there might be question and answers. So if you can limit your talk about 20 minutes, probably we'll have some time for Q&A. Inshallah. We will first start with Dr. Zara Han. She will be talking about the women's right as human rights, categories for Islamic ethical reply. And later we will go to Dr. Paul MacDonald. Can Islamic ethics demonstrate the rights of self-governance for religious communities? So without further ado, I would like to invite Dr. Zara Han. Dr. Zara Han is an American Muslim educator and researcher, holds a doctorate with distinction in political science from the City University of New York Graduate Center, under the mentorship of Susan Buck Morse and with the guidance from the late Young Kum Kim. She studied Western political thought and political economy. And then the CV, the short introduction goes on, but let me just summarize. Han is an author of Morality, Reimagining the Waqf, using a classical Islamic institution to dismantle structural injustice. Dr. Han, thank you very much for being with us, and we look forward to your speech. Please go ahead.
Jazakallah khair. Assalamu alaikum wa rahmatullahi wa barakatuhu. Good afternoon to all my esteemed colleagues. Thank you so much to CILE Center for having graciously welcomed me to the beautiful country of Qatar and to this illustrious conference. It's my honor and my privilege to be here. So let's just jump right into it. The topic of my paper today is women's rights as human rights, and going to be look at some categories where if we put political science and the politics of gender, looking at human rights as a moral framework into conversation with Islamic ethics, what are some areas where I feel that Islamic ethics, inshallah, can make a contribution, which requires that I identified some problem areas. Sorry, I'm a deconstructionist, I can't help it. So that's the plan for today. Just going to introduce my problem, followed by 4 deconstructions. Issues that I find with some of the premises of universal human rights, and going to finish by spending a little bit of time making some propositions as to where some constructivist work can be done. So, as was mentioned, my field is political science. I don't have a formal study or background in Islamic ethics or other ulum ad-din, so my paper today is going to be presented from the subject area that I know, which is political theory. And, looking at human rights as a moral framework, I'm going to start with a very basic definition of what is universal human rights as a paradigm and a discourse. And really, we can think of it as the moral law of the modern nation state. The modern nation state is not like other forms of government that have come before it, and this is a particular form of, by consensus, by agreement, a form of moral restriction that states opt to impose upon themselves for the protection of individuals within those states against the excesses of state power and state abuse. So it's not necessarily a relation between groups of people or even between groups and states, but really has to do with the nation state and the individual. It is based on the dignity of human beings as given, and I'm going to problematize and ask what the basis of that is, if it's just accepted as given, but we're not told what it's rooted in, but we'll get to that in a little bit. This is very goodwill expressed in even just the basic beginning definition of human rights. But we have to remember that sometimes, Dr. This morning in his presentation mentioned that what happens when the state can corral with the rule of law the expression and the exercise of certain freedoms of universal human rights, like freedom of religion, under this concept of public morality, right? It's open to so much interpretation that sometimes human rights can become politics by another means. That doesn't mean that's how we evaluate it, but it is a dimension nonetheless that has to be reckoned with. So in this discursive encounter between human rights and politics and the politics of gender, and Islamic ethics as a general and broad worldview, which is the only level at which I can speak about it. The four areas that I'm going to ask that we look at a little closer is, number one, there is a specific type of human being that is implied in universal human rights, and that is a morally autonomous human being. And not only are we morally autonomous as subjects of human rights, but we are aiming towards a very specific end in life, or a telos in life, which is the telos of unlimited progress or teleological ascension. This is an enlightenment inheritance, and that is the theory of the human that is implied in it. Number two, when we look at the freedom of religion norm more closely, we find that what is defined as religion is disembodied, privatized belief. And we will have an opportunity to talk about what Islamic ethics as a discourse can contribute to expanding that beyond a disembodied form of belief. Number three, we're going to look at Wael Halak's commentary on the metaphysics of the modern nation state. Remember that universal human rights has to do with constraints upon nation states so that they don't access and abuse power against individuals in their states. So what is the modern nation state in its metaphysic of sovereignty? We're going to look at that. The last one I'm going to ask us to look at critically is the claim that human rights don't rest on any philosophy. That because they don't adhere to any specific religious commitment or particular belief, that is the reason and the basis of their universality and why they can be appropriated by everyone, or why they ought to be appropriated universally. So looking at the first one, the morally autonomous human being, we'll take these three basic features of a morally autonomous human. Self-invention. Okay, I'm speaking from my own context. I realize being an international conference, people are joining from Muslim majority countries, people are joining from, I'm joining from the United States, very different particular contexts, very specific historical problems, depending on where you're coming from that you're going to be dealing with. So in my context, self-invention over the last, let's say since the 1990s when post-modernity was really becoming the normative social value and fact, really means that nothing is determined about human nature. So not just in the Enlightenment when there was a kind of an obsession with the origins of things and really a desire to identify the essential natures of things, there's been a rebellion in the Western episteme in the last 150 years against that tendency. So now we've thrown the baby out with the bathwater, so to speak, and now nothing has an essential nature. And if it does, it cannot be known with any degree of certainty. So self-invention has been the cultural byproduct of this lack of certainty as to human nature in any way. So you know that people may identify their own gender and have sex-affirming surgeries, and other than that, even if we look at patterns of consumerism and popular culture, there is an obligation, especially on newer generations of Americans, to constantly reinvent themselves. And that can be made up of a number of things. Maximize pleasure and minimize pain is also one of the key features of the morally autonomous human being of today. And Alistair McIntyre, when he talks about in modernity, after secularization, when ought becomes is, right? And he has his own commentary on the is-ought dichotomy. He says that we end up with the practical syllogism for action as maximize pleasure and minimize pain. It's the only reason moderns do what we do as a general cultural fact. So that is another dimension to keep in mind. The third one being history making. This is very general, again, spirit of the Enlightenment. We can think of Hegel and his reason in history, and when he provides us with this survey, which is really the theory of evolution put onto political space and history, and says, you know, human beings used to be very simple and not complex, and didn't really enjoy freedom. And it was only one person in society who enjoyed freedom, and that was the despot. And this is ancient China and ancient India and ancient Persia. And everyone else was unfree. All the subjects were unfree. And little by little, through the Roman world and the ancient Greek world and the Christian world, you have increases in how many people in society enjoy freedom and what forms of freedom are enjoyed. And little by little, the human being, as a species in a single civilization, begins to throw off the shackles of unreason and unfreedom, which for Hegel and the Enlightenment fathers are the same, two sides of the same coin. We end with an idea that to be a fully realized human being is to partake in history making. So I won't go into more details because I'm on a bit of a time restraint. So thinking about this from a theory of the human being which deals with the faculties that as Muslims we understand every human being has specific faculties. We know we have ruh, we have a spirit that can't be corrupted, and that is the breath of the most merciful that was given to each human. We have a qalb, but for us qalb is not heart in the sense that we use the word heart in the United States, right? We use it in a very different way. Qalb is the seat of intuition in the human being, and it is a spiritual substance. The way that we use it in American culture, we use it to speak about the nafs, but we use the word heart, right? So just to be clear, aql, of course, the rationation faculty, but nafs, you see the nafs, the appetites, can be traced to these imperatives for the morally autonomous human being. I'm trying to suggest to you that postmodern and modern man and woman is essentially becoming more and more nafsani as a cultural phenomenon. And we're going to keep that in mind for human rights because it's a human being that is implied within the language. Disembodied, privatized religions. As I mentioned, when we look at the freedom of religion norm, we find that the way that religion is defined, alhamdulillah for the protections that are afforded, to assemble and have holidays and to congregate, to raise children in religious education. There are a number of freedom of religious kind of factors there that are very important. And at the same time, one of the things we find is that there is a strict separation between the realm of religion and any realm which today we consider secular, so economics and politics. It's considered very strange for any society or group of people who would want to mix religion with any of these quote-unquote secular realms. And that is what, following William Cavanaugh and his work, we call disembodied religion. After the Reformation, after Renaissance humanism, throughout the Enlightenment, we have, looking at the intellectual history, we have a tendency to not just drop the idea of salvation into the hands of the individual consciousness, but this continues to grow as an idea and as a practice, and really, by faith alone really becomes, faith is in my heart. It's not necessarily in the hands that give to charity or the tongue that holds itself back, from uttering something foul, or in the body that refuses to fornicate or adulterate. Religion becomes separated from the disciplines and the habitus and the practicums of the body. This is as opposed to what religion meant in the Western world prior to the advent of modernity. So in the Christian world, we have what Kavanaugh called the theopolitical whole. There was not two realms being brought together, but it was a single whole, which encompassed all of life, from family obligations to civic cults and virtues understood socially to the political structure as well. If we look at pre-modern religio, which is what Kavanaugh was just describing, and then compare it to the distinction that occurs after modernity, we'll see we consider religion now to be a purely interior impulse. And before that, there was a sense that in order to bring the soul closer to the divine, you had to discipline and act upon the body. We also had a concept in pre-modernity that the body and the soul were a single unity. And after, let's say, Descartes and the mind-body dichotomy, and after a number of permutations in Western political thought, we understand just the interior space of the human to be where any fruit or origin of faith can reside, to quote Thomas Hobbes. The next one is the metaphysics of the modern state, and these we also find as the subtext in universal human rights paradigms. So we know, this is from Halak telling us about the 5 essential properties or forms of the state. We know that the way to define the modern nation state is a monopoly over law or violence. That's a basic definition. States are characterized by bureaucratic structure, and we have work by Michael Parenti talking about public bureaucracies, and Andrew Duboff examining the development of bureaucracies in a global capitalist system. Halak also is pointing us to, as he is always concerned with subjectivity and subject formation, the cultural hegemony of the modern nation state in creating conditions for certain types of national subjects. Now, with respect to the metaphysics, Halak tells us that the nation state exists only for its own sake, so its final cause is its own existence. Not only that, but the modern nation state can and does expect its own people not just to go and die for it if needed, but to go and kill for it if needed. So this we're keeping in mind, because one of the things that, and these are just my thoughts and I'm working through them, so I also haven't landed yet, but one of the things that I thought is, we think of universal human rights today, we can think of it as the denuded rationality. Halak is making commentary on Abdurrahman Taha's use of this criticism, right? Denuded rationality, looking at some of the Arab and Islamist reformers and saying, well, what they're missing is rationality within the context and the broader contours of Islamic thought, life and thought, but stripping it from its psychoepistemic matrix and taking it as something very Enlightenment, very secular, very empirical rationality only, right? Devoid of those other more meaningful cosmic principles. So we can think of human rights in the broadest sense, right, in the broadest theoretical sense, as denuded rationality, but expressed in the language of Kantian and Rawlsian law of nations. And the reason I'm calling it a denuded rationality is because it claims to be foundationless, and thereby it claims to be universally self-evident, right, and not requiring any demonstration from any tradition-rooted argument. But, and we'll get to that in the following couple of slides, but Kant in 1799 had published a paper, the universal idea for universal history with a cosmopolitan purpose, and really it's like a precursor to, you wouldn't know how much time had passed between the publication of this and the passing of the UDHR in 1948, because it's really a page out of the book. And in it, Kant is telling us, among other things, not only is it hard to create a just society, but it's hard to have a just political society if the other countries in the world are also not so, right? So this is the theory of liberal peace, still with us very much today, the idea that, liberal countries don't go to war with each other. Therefore, if everyone was liberal, we would eradicate war. I'm being oversimplistic, but this idea that liberalism as a political project is ever expanding, right, is very important to the political context of universal human rights, because at the time that the UDHR really kind of, in its celebratory dramatic birth and in the years subsequent, it took a few years, but when it became extremely and exceedingly popular and well adapted, it was really the victor among what Samuel Moyn has called the competing cosmopolitanisms of the time, or the competing internationalism. So there was more than one way to think about being international between the two great wars, but this universal human rights paradigm, this liberal political paradigm, is the one that won the contest, right, over the social democrats, over the post-colonials, and this is the one that kind of championed. So when Kant gives us this picture that the more countries in the world are peacefully liberal, the better it will be for one to have a peaceful liberal society at home, he is basing this, remember, building it upon his own definition of moral action as being deduced rationally and secularly, right? You don't need to be rooted in any tradition. Oh, that's impossible. Okay. I'm sorry, maybe we can get next, because I prepared for 30 minutes, so I'll cut it a little bit, but I don't think I can cut it in half just at the last minute, but okay, Jazakallah khair, brother. So remember that this is rooted in an idea that moral action can be universally deduced without recourse to any tradition, belief, or specific philosophy. I don't, of course, believe that the Enlightenment was a specific philosophy with very specific values, although it claimed to be universal and purely rational. But let's continue. This is also a Rawlsian law of nations, because John Rawls, an American political philosopher, contemporary, the biggest contemporary liberal philosopher, he gives us this map, political, not metaphysical, he says, is the way to achieve not only a just society, justice is fairness, but also a law of nations, right? A law of peoples. And it's interesting because in his schema, political liberalism is like the master science that is going to decide how other countries, illiberal countries, can come and participate in a law of nations, right? So the liberal countries are like gatekeepers in this schema. I'm bringing all of this up because it's important within the context of what are universal human rights, right? They have a specific origin story. Everything has a history. Every concept is a storied concept. And if countries, according to Rawls, don't espouse universal human rights, and these are countries that are not liberal, right? They are religious and they're hierarchical. They don't follow liberal political ideals. But he says we can still have them in the community of nations, but they have to follow human rights. So human rights becomes the standard barometer with which a country may or may not be allowed into the law, into the community of nations on the earth. And Rawls says if they don't, well, then it's okay to engage them militarily, which is, of course, we have to now take that out of the realm of just theory and just an intellectual exercise and really try to count the number of times my country, the United States, has intervened militarily 1800s, 1900s through today into other countries. So again, this question, sometimes human rights is actually a vision of a moral good, and it is in fact a moral framework, and at the same time, human rights is politics by other means. So it becomes impossible, I think, to try to purely separate these two dimensions of human rights and study them independently. We'll just continue. This idea that human rights are foundationless is espoused across different approaches. I will skip the approaches here, but we can think of a moral autonomy approach, which is rooted in Kant and has, of course, contemporary interlocutors as well. We have the human dignity approach, Jack Donnelly, Adam Gearworth, and others. And these basically say that we have a very neutral. We don't have a philosophical anthropology in human rights. We don't have a theory of the human being that we espouse. You can believe anything you want about the human being, and you can still espouse unproblematically this neutral standard, right? When we look a little closer, we find that, for example, we had this morning a wonderful presentation that spoke about Imam Izzuddin's schema of Hukuk Allah and Hukuk al-Ibad. One of the thinkers from the dignity approach, Jack Donnelly, very prominent thinker in this area of human rights, he says that, when he's looking at Islam, when he sees arguments where Muslim thinkers or groups try to appropriate human rights in a way that makes sense for their normative values, their societies, their tradition, he finds this argument that some rights are the rights of God to be quite literally incoherent. So there may be limits to those approaches and finding those degrees of overlap precisely because there's a subtext to human rights. There are broader categories about what is the human, what is religion, that underlie some of these tenets. And then we have a minimalist approach, also known as a purely political approach, which John Rawls does espouse. This is an interesting quote from MacIntyre. He says that one of the central characteristics of cosmopolitan modernity is the confident belief that all cultural phenomena must be potentially translucent to understanding, that all texts must be capable of being translated into the language which the adherents of modernity speak to each other. And I think this is an interesting critique. We know, MacIntyre, he's a communitarian. He's a critic of political liberalism, and he finds it to be one tradition among many traditions in the world, and not just the one which is tradition-free and universal and self-evident. So moving to some constructive propositions, when it comes to the moral autonomy of the human being, we know that as Muslims, not even our language is autonomous. Our knowledge is not autonomous, right? Knowledge comes only from Allah. And our language came from when Allah taught Adam the names of things, names being ideas, concepts, and an intimate knowledge of life on this earth. And that is who we are as a species, right? Even more than Aristotle's famous notion of us being political animals, we are the linguistic animal. We know that the human being accepted the trust that even the mountains were afraid to take up, and this forms not a morally autonomous creature, but a creature which from the beginning is in the position of a slave before the rububiyah of the Lord. Also the viceregency of the human being, the khulafa of the human upon the earth, as opposed to moral autonomy, it does present a truly alternative definition of who the human subject is before we can begin to insert ourselves within human rights discourses and schema and practices and norms. With respect to this concept of teleological ascension, meaning that in every moment that passes, the human being as a civilization is becoming more rational, more free, more complex, more superior, right? That as time goes forward, we get better. And that which we leave behind is somehow inferior to what comes next. This is still very much a part of the way we understand the movement of time as a Western civilization, even if it's not exactly the way that, Haeckel and Hegel were espousing it many years ago. But we have a different conception. We know that Allah tells us that people before us were destroyed by Him for making the same mistakes that we're making right now, which adds a layer of moral accountability, which goes way beyond this idea that as we humans move through time, our civilizations are just getting better and better and better. Maybe technologically, but not morally necessarily. The end of infinite progress, Allah tells us in Surah Al-Ma'un and Surah Al-Takathur that we have to be mindful of the greed for accumulating more and more, which is a companion to this concept of infinite progress. With respect to disembodied and privatized religion, here we have a number of thinkers. There is a rich literature. As you can see, I'm just a little more familiar with this one than some of the others. But here we find Halak and McIntyre. We find Sabah Mahmoud's work on the pietists and her conception of habitus. Tal al-Asad, when he speaks about the difference between secular homogeneous time and heterogeneous simultaneous temporalities, because to perfect a devotional act or a devotional practice, you reach back into time. You need time to perfect it, and that's not the same. It can't be translated into homogeneous national time. Elsewhere, when Asad talks about tradition, he's letting us know that there are always entries and exits and ruptures in tradition, right? A tradition is not just a discourse that you learn. It's not book learning. It is a capacity for experiencing that can't be denounced, right? It's a very beautiful definition. McIntyre on tradition is always my go-to when I'm teaching political theory, which is an argument extended through time. And it has to be dealing with discussions and disagreements within the tradition over the meaning of key principles, but also critics outside who have very different foundational beliefs. We have Alparslan Asikench's definition of worldview as the broadest, he uses it like the word episteme, the broadest framework in a person's mind that would allow knowledge to be produced in the first place. So when we look at this, when we look at Abdurrahman Taha's definition of tradition and the ideas of praxis, what we see is that the human being does not experience religion in a disembodied and a privatized way, but it's through tradition, as defined by these thinkers and others. This is something I've spoken about this elsewhere, but when we look at Sayyid Muhammad Naqib al-Atas's work, The Prolegomena to the Metaphysics of the Worldview of Islam, he has a section where he goes into the etymology of the word deen, the three-letter root of the word, which for us means religion, but as the slide is trying to show, it means so much more than what we mean when we use the English word religion. We say religion, we think of what you believe, and you do it in private, maybe your family life is affected, and that's about that, communal practices, and that's about it. But deen, just without departing from the etymological study here, not even adding interpretations, just looking at the cognate, the three-letter root and the words that come from it in Arabic, we see that deen has to do with debt and credit, legal judgments, convictions, commercial life, towns, cities, and even, Bildung, right? This German concept of building civilization, cultivating and nurturing the higher dimensions of human life and civilization. When we look on the side of disembodied religion, we see that all of these categories, economy, law, commerce, politics, these all belong to the secular realm and really have nothing to do with religion. And what I'm suggesting at this dichotomy and the disembodied side of this chart is what is implied in universal human rights discourse. So it becomes difficult as Muslim individuals, groups, societies, or nations, I would imagine, to try to bargain the meanings of certain human rights ideas and norms when the foundation of what religion even means can be so different. So remember the theopolitical whole, our concept of deen is much closer to what Kavanaugh was describing of the early Christians than what we mean by religion today. With respect to the sovereignty of the modern nation state, in pre-modernity, and we see this in Sherman Jackson's work, and we see this in Wael Halak's work, there was a organic matrix where life and law were, you did not need these special bureaucratic structures or hoi polloi language to be able to navigate. Plaintiffs spoke plainly, and the separation of law and power allowed this to happen because administrative political power was one dimension and in charge of taxation and administration and security against external threats and putting down rebellions within the realm, but law, because it was allowed to function independently, was able to provide for society what it can no longer, because the Sharia has become something that, because it belongs to religion proper, and because the modern nation state does not share its monopoly over law with anything, with any other entity, has become impossible. So I will just skip forward to this last point, that foundationless human rights. Again, universal human rights says we're not rooted in any philosophy or religious belief. That's why we can be appropriated by everyone. But I'm going to draw your attention to this great Orientalist scholar of the Quran, Toshihiko Izutsu, and his wonderful work, God and Man in the Quran, where he does a semantic study of the Quranic words and their relations to one another and the semantic structure. And what he finds is that in language, in the Quran, you have complex webs of interconnectedness. You'll have a word, but the meaning of a word depends on so many other meanings of words. And it's possible to examine a word singularly as part of a web, and it becomes the focus word of a web. But what Izutsu tells us is that, the webs interact in different ways and they relate to each other in different ways. But Allah is the highest focus word in the Quranic vocabulary, and it reigns over the entire domain of the semantic structure of the Quran, and it reigns over every single focus word web, every conceptual linguistic web in the Quran. The reason I'm bringing this up is that, and we have Halak telling us in Reforming Modernity, that interconnectedness and interpenetration are the most salient features of the Islamic tradition. So what I'm suggesting is that, well, two things. Number one, it's been suggested that ethics is the core of Islamic tradition and Sharia considered as an indivisible whole. But my question is, if ethics is the core, where is Tawheed? It seems to me that maybe the kernel of the core should be Tawheed. And the reason I'm saying that before these examples is that I think just from a political perspective that I've shown here today, the most important contribution that Islamic legal ethics in my part of the world can make to the conversation around human rights is to bring back the name of God in a very theologically confident way, right? Our ethics are not just at the political and social levels. That's not where they operate. They're not rootedless. Even if universal human rights claims to be foundationless, our ethics are not foundationless. So perhaps to bring the theological center back to the conversation with those who do have other beliefs, I think may be the best contribution that can be made. And here I have some examples because one of the conference organizers asked me to make sure that I'm bringing some constructivism here as well and not just a deconstruction. But I have here some thinkers. So the first pair On the left side, we have Abdulaziz Sachedina and Abdul Hakim Murad, two contemporary Muslim scholars who are Western scholars, and they write in languages accessible to Western audiences. You see the way that they define fitra. Fitra is a very essential concept for Muslims and for the Islamic worldview. We have Sachedina defining it as universal intuitive reasoning, and this is the argument he makes for why Muslims ought to adopt universal human rights norms completely, and that there's no contradiction or anything of the sort. Abdul Hakim Murad doesn't speak directly about human rights, but he defines fitra as primordial God consciousness, that every person is born with a knowledge of God, and then like Plato, we forget and then we need to remember, right? But it's a very different way of defining it, and so in Murad's scheme, any philosophy that's reigning, any set of norms, no matter how universal it is or says it is, or how popular or unpopular, it needs to be investigated more closely. What are the assumptions underlying it? When we look at the late Fatima Mernissy's work and Canadian Muslim political scholar Catherine Bullock's work, and we see what they say about hijab, Mernissy had a very unfavorable opinion about what the hijab is, how it came to be, why it's still around, and what it does to women today. Very negative evaluation, really based on her own teleological vision of history. And you see this throughout her works, Islam and the Fear of the Modern World, Veil and the Male Elite. Across her works, you see this, she's replicating the teleological historical vision of the Enlightenment and modernity. And so for her, hijab is like moving in the wrong direction. Bullock, on the other hand, she puts forward a different epistemic proposal and says that women's experiential knowledge through the hijab is very valuable because through it women are able to successfully foil not only capitalism but also instances of the oppressive male gaze. And this is for her part of the project and the aspiration of creating a good society. So this is more of that tradition, habitus, praxis way of looking at what the meaning of hijab is, and Mernissy's is more perhaps more of a modernist epistemology. And the last example here we have Abdullahi al-Naim and Tariq Ramadan. And we have on the question, for example, of whether a Muslim majority country ought to mention Sharia or the Quran in their constitution, Abdullahi al-Naim is very strict about saying that this absolutely should not be done, and really goes so far as to say that what Islam needs is to go through its own reformation, the way that the Protestant Reformation, what it did for Christianity, that we basically need the same thing, and a secular state is the only way a Muslim can fulfill their faith. And Tariq Ramadan, has said that because a constitution is a founding document and it has to be able to draw upon and espouse the most valuable codices for society, right, culturally and spiritually and all of this, with respect to values, that of course, if a country were to put Sharia in its constitution because that made most sense for it, that would be fine. And really we could look at Ramadan's kind of epistemological proposition for how experts from different fields need to sit down with scholars of Islamic sciences in order to come up and generate creatively answers to the questions of today and tomorrow. We could put that against a thinker like Sarouche, and there are many examples in the contemporary literature where you see tendencies towards putting Islamic ethics as a framework kind of central to a treatise on a given topic, as opposed to what I would consider to be a replication of just the same old modernist epistemology. So, Jazakallah khair, I thank you for your time. If there was any good in it, it came from Allah, and please forgive me for any of the mistakes. Jazakallah khair.
Thank you. Thank you, Dr. Zara. So without further ado, let's move to the next presentation, and then we will get the questions at the end. Can Islamic ethics demonstrate the right of self-governance for religious communities within a state? By Dr. Paul. Dr. Paul is a lecturer in law at Cardiff University, where he teaches the contract and the EU law. His main research area is the international and comparative law, often related to human rights. Particular interests include Islamic law, refugee law, and EU fundamental rights law and constitutionalism. He also JD from University of Michigan and PhD in law from Trinity College London. So, Dr. Paul, please, the floor is yours.
With apologies, as a matter of nationalism, I have to correct it. It's Trinity College, Dublin, Ireland. And we will decide supremacy on the rugby pitch soon. Assalamu alaikum. I realize we're short on time, but I nonetheless have to take just a moment and give thanks to CILE, the organizers, the Qatar Foundation. This is quite a privilege and an honor to be able to be here, and I am taking notes like crazy, learning a lot, so thank you to everyone. And now the apology. I'm bringing you another lawyer. In choosing this topic, I tried to identify a path less traveled in the discourse, and also one where someone of my background might be able to contribute something. I'm basically a European human rights lawyer at this point, so again, in advance, I ask forgiveness if a fair bit of my analysis goes by analogy to European situations. The topic I've tried to look at stems from the fundamental right of self-determination. It's now taken to be a jus cogens norm, and is, at least formally, one of the most fundamental human rights there is. It's in, as an author by the name of Doering pointed out, it's in too many international instruments to even actually count them. It is arguably the right that enables all the other, at least political rights. And it's by no coincidence is it at the very front of the ICCPR. At the same time, it seems to be falling into some disuse, with the glaring exception being the Palestinian debate. Other than that, it seems to be a formal right that isn't really practiced anymore in what is largely a post-colonial age. Also, unlike most of the other human rights in the international treaties, it's a group right, which suggests to me that it might be amenable to a certain amount of rethinking from an Islamic perspective, because Islam focuses far more on the community than the Western human rights discourse tends to. At the same time, I have to acknowledge that it's a bit of a risky topic. There might be very good reasons that this path is less traveled academically. There might just not be very good answers available. So I'm trying to explore this. The starting point that I have to go with is the internationally recognized right of self-determination. I'll quote quickly from the ICCPR just to give us a starting point. So all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. This raises several analytical sub-points, one of which is, what exactly is a people? As far as I've been able to find, this is not particularly precisely defined in jurisprudence. There are certainly indications in history that it has to do with an answer to the problems of empire and colonialism that have caused so much problems. As far as its substance, it seems to me to be characterized by factors such as language, ethnicity, cultural traditions, shared historical experience, which surely extends to include religion and religious communities. So, in giving content to this right, the ICCPR goes first to, as I said, political status, which will largely be understood at the time as national independence in the era of the post-Habsburg empires, and sort of codifying those lessons in the post-Second War era. It raises also the possibility, if rather than independence, might it extend to a group choosing to affiliate with a particular existing state, or perhaps having some form of a devolved administration, as in Wales. but certainly, I think the Hughes-Kogan's norm now focuses on colonialism. Certainly we can say, as far as political status goes, this right is a right to be free of colonialism. On the second or the third part of this ICCPR provision, dealing with economic, social, and cultural development, seems to be analytically fairly straightforward. I would say that if there's a line between that and political status, it comes where core state interests would be implicated. I'm going to come back to that point toward the end of the presentation in discussing whether this right is possible to implement while disregarding statehood. Arguably, if there's one thing that characterizes economic, social, and cultural rights, they would be inherently interdependent on each other. So the social and cultural rights would be dependent on economic development and so on. And also there's arguably an international aspect. It's hard to develop in the modern world for any people in isolation anymore. So looking at this now from a legal point of view, I want to look briefly at how self-determination looks in international law and how it might look in Islamic law. And I do acknowledge there's a distinction between Islamic law, Islamic ethics. I'll carry it over to ethics towards the end of the presentation. In international law, formally, it's pretty much everywhere. It's nearly identified with non-colonialism. De facto, it does seem to be nearly dormant as far as any kind of a discussion goes, except for some fairly recent, by which I mean last 20 or 30 years, jurisprudence that has developed the duality of external self-determination versus internal self-determination. So the problem with self-determination as classically understood is that it involves changing the borders of states, and most states don't really want to have borders changed around. That's how wars get started and so on. So as the leading case, I think, on this is from the Supreme Court of Canada, declaring that Quebec does not have a right to secede from Canada based on international self-determination, because most of what they would get from self-determination is available within Canada. So Quebec is influential within Canada, has a separate language and culture, and so on. And by influential within Canada, I mean within the federal government. So, in fact, the Prime Minister is Francophone as well at the moment. So the debate seems to have turned to where external self-determination is a dead letter, except for the glaring exception of Palestine. And then the question becomes whether a given state is affording a people enough internal self-determination. Looking from the Islamic side, it's a bit hard to fit Islamic and international law together on this topic, but I found some hints, and indeed some have been provided in this conference. The idea of the Ummah is central to Islam, so it's community-based, and thank you for the previous presentation. It's in the Quran that there is also a global Ummah in addition to the Muslim Ummah. So this idea of a community being able to stand apart, I think, is embedded in Islamic history. Certainly there's a precedent. If the Hijra was not an expression of community self-determination, then what was it, essentially? Also, I think there's a second hint in the Dhimmi contract that acknowledged the right of religious communities to live as religious communities within a larger Muslim state, I think we can call it a state by then. So what we have is the state-centric nature of classic international law leaves, I think, a fair-sized gap in peoples who don't have a right of self-determination because they are unable to express their identity but are not subject to a colonial regime, and also other communities that have an identity that crosses state borders but and because of that fact are inhibited from expressing a unified identity. So the question I have now is, can Islamic ethics serve to help revive this right and bring it back into live jurisprudence as opposed to mostly a matter of history? International law simply is not well equipped to stretch beyond states, although efforts are ongoing and in the particular area of human rights, I think, have been successful. But classic international law remains mostly state to state. I think we can also say that whatever Islamic ethics has to offer to this question of the right of self-determination, it doesn't depend on a state system because of the universality of the Ummah and the dual nature, the two Ummahs. So beyond that foundational idea, we have solid foundations for Islamic ethics in the Quran, and here I'm coming as a beginner to a room full of experts, so I'm just reading my notes with apologies. It's in the Quran that God has gifted humans with an innate knowledge of right and wrong, good and evil, and as others here have observed, the Quran says no compulsion in religion and celebrates a plurality of communities, which is starting to move towards at least an open door to the idea of self-determination despite state structures. There's a principle of freedom of belief. There's extensive literature from the classical era on a duty of the ruler to rule justly under Islamic law, but that surely implies an equivalent right on the community, to be ruled justly. An author by the name of Katja Samuel has tied this idea of Islamic principles of justice and the lesser jihad as a means, a duty of defending the Muslim Ummah to together compose the elements of a right of self-determination. I would say that arguably this would be even more evident in the higher forms of jihad. And I think it further ties towards Professor An-Naim's observation that a secular state can realize Muslim values and therefore would be, I don't necessarily agree, I must say, with Professor An-Naim's constitutional views, but I do believe there's something there in the idea of the struggle to come to a better view of Islam and a better society that composes the higher jihad, playing through into eventually an understanding that the community can step aside and define itself despite state structures. So, the way I'm trying now to view this right of self-determination is apparently a paradox. It's the right of self-determination, external, but without creating a new state. I try to think about that analogously to what I was taught in ancient times at University of Michigan about property law. Take the attribute of statehood as a bundle of, take statehood as a bundle of attributes analogous to the property law idea of property being a bundle of rights. So the text I borrowed for this is actually the Arab Charter, which talks about, it's the one international instrument I found that actually tried to subdivide the right of self-determination a little bit beyond the ICCPR. So it talks about self-determination of peoples with control over natural wealth and resources, the right to freely choose their political system and to freely pursue their economic, social, and cultural development, as well as the right to national sovereignty and territorial integrity. So that's 5 different aspects of a right to self-determination found in the Arab Charter. The first of these, control over natural wealth and resources, sounds to me slightly analogous to the Dhimmi contract. Have your economy, have your culture, have your resources, pay a tax for the state functions of defense and basically maintaining some kind of an orderly society on the outside so this community can fulfill itself. The second one, freely choosing the political system, like I said, sounds a little bit like a devolved administration in Wales. We do have a separate government. We can, within some limits, run it as we choose. And again, it's sounding from the example of Wales in internal self-determination. I'm thinking maybe it could be extended to external self-determination and extend as far as to a religious community. Similarly to, here is where I pluck European examples from all over the place, because those are the constitutions I've studied most in addition to those of Islamic states. And there have been more experiments in federalisms in Europe that I've read about than in the broadly in the Islamic states. The idea of pursuing specifically economic, social, and cultural development within a community sounds very similar to the Constitution of Belgium, where, at least in principle, the federal state is very thin, and then a lot of these rights over things like language and education and so on, governance over those things, fall to either what is called the community, which will be depending on what native language someone chooses to identify with, or the region, which is physically what part of Belgium is it. Again, I think by analogy there might be something there to work with the idea of a religious community having self-determination despite state borders getting in the way. Coming down to the fourth one, the right to national sovereignty, and fifth, the right to territorial integrity, that's where I think I would have to admit that at least in the classic international understanding of the right to self-determination, it can't be divorced from the idea of state structures. At least I don't see it, how you can have the right to national sovereignty without being a state. And just as I say that, I think about Wales being a nation within a state, but I still don't think it fits into the external self-determination paradigm. And especially on the last one, the territorial integrity would also be difficult in terms of needing to, I think in actual negotiation and practice, it would lead to, I've got about 3 or 4 minutes left. In negotiation and practice, it would have to lead to a series of particular solutions for particular geographies around things like who has permission to live there and who has permission to cross the boundary for what purpose. Which brings me to the last question I had is very speculative. It's how could conclusions and agreed norms of Islamic ethics translate into and influence human rights law, which, for better or worse, is today's main human rights language, or perhaps it's the only one I speak, so it's what I think the main human rights language is. But just thinking speculatively, what if the Prophet had found a level of welcome or tolerance in Mecca? Would there have been even a necessity to establish a new polity, or might the community have been able to achieve its fruition within another political entity? Or for that matter, what if after the Hijrah and families had been willing to reconcile themselves and say, okay, you to your religion, we to our religion, but at least we don't have to have wars. So that to say, in my understanding of Islam, this would be a conversation that could happen from the sides of Islamic ethics. It's just a matter of making the international lawyers listen. There are enough Islamic states, enough states in the Organization of Islamic Cooperation to carry a lot of weight in international customary law and to have a lot of influence in any treaty discussion, or indeed any declaration of the OIC has to carry some weight in international discourse. It could be demonstrated also by state actions that do start to recognize something at least in between internal and external self-determination, whether that be through some form of devolved powers or federalism or just de facto understanding within and between neighboring states. And I would imagine at least that this might lead to a broader interpretation of treaties such as the ICCPR, following the Vienna Convention's rule that the meaning of a treaty can have can't really be changed, but light can be shed on the meaning of a treaty by subsequent state actions showing how they understand their commitments. And just perhaps this might mean that international law of human rights could be susceptible to acquiring, the international law of human rights specific to self-determination could be susceptible to acquiring normative force through the language of Islamic ethics, even if it is not labeled as this is Islamic ethics. That's my conclusion. Thank you very much for your attention.
Thank you very much. So we have about an hour past, so we make the equal distribution of time. Right now we may get some questions, and if you have any questions you want to raise. Inshallah. Professor Gali, please. You may.
Yeah. Okay. Assalamu alaikum. Thanks for the two interesting presentations. I have noticed that the concept of human dignity is coming over and over again all the time, and it's clear that it is fundamental to the whole discussion of the human rights discourse. From my field, and as an applied field, Islamic bioethics, and the fields close to mine, like environmental ethics, for instance, this concept has been problematized, questioned, and to a certain extent challenged. So I would like to share these thoughts and see how far you see this. In environmental ethics, for instance, human dignity is seen as a problematic concept because it gives much higher status to the human than to the other creatures, and this contributes to damaging our environment. So we should get rid of this human dignity, and we shouldn't be looking into the creatures as living in hierarchy, but it's a circle, and we are helping and supporting each other. And sometimes you find, even outside the Islamic tradition, ideas like we all evolved from ancestors who were non-humans, and at the end, so why would the human be that, and human dignity would be that central? In the field of Islamic bioethics, one of the main applications of human dignity is physical integrity. So we cannot touch the body without getting consent, especially informed consent, from the patient or the research participant. By time, this also became quite problematic. So in the beginning, it was used as an argument against organ transplantation. At the end, we tolerated it because we are saving another human life. Then it was used against euthanasia. So we cannot kill the person, we just have to preserve life by time, different countries started by the Netherlands, and other countries followed because of the autonomy of the person. You can decide about this. So people are saying human dignity at the end, if you apply to specific practical questions in bioethics, and it will end up to doing whatever you want and not allowing whatever you want. And then in the human rights discourse, are you up to these discussions yet, or you take it for granted, the human dignity, as if it's a clear concept, and then you go further and building the rights upon it? Because as I show in other fields, it is quite problematic, the concept. How do you see that? Thank you.
Thank you. To Dr. Zara, I guess. Yes, or both. Or if would you like to respond immediately, or we may get a couple of questions and you respond all of them. There's another question from there.
Thank you very much. Thank you, both speakers, for a very resourceful, presentation. Dr. Zara, I was really hoping, and I don't know what you think about this. I know Halak is opposed to it. That is the concept of the social contract. I was saying, when you were talking about, Islamic ethical replies. Halak, as you know, believes that, this is fake. It never happened, particularly in relation to the nation state. But it's an important aspect of the foundations of human rights, whereby there's a presumed social contract, whereby, people decided to relinquish their executive rights to rulers, the state, on the understanding that the state will fulfill all their other rights. Now, from an Islamic perspective, I want to connote, for example, you also talked about amana and the concept of Khalifa, Khulafa. And I felt that even within Islam, within Islamic provisions, Allah says that He created Adam as Khalifa, and we all as human beings, being children of Adam, we inherited that. So we are all entitled to be a Khalifa because we inherited it from Adam. But we cannot all be a ruler at the same time. We cannot all exercise our rights of Khilafah at the same time. Therefore, one could argue that, in selecting rulers, we have transferred our executive powers to our rulers. And if you see Al-Mawardi and others indicate that, leadership has certain duties to the people, that is, to fulfill our rights. And the Quran says, Inna Allah ya'murukum an tuwaddu al-amanati ila ahliha. Your God commands you that you should return the trust back to the people. And the reason why I think this is important is that a lot of the time, many of the points we've been talking about, Allah is the main sovereign, that we are only accountable to Allah. My perspective of the concept of the social contract from an Islamic point of view, the Khalifa, is that now for the fact that we as human beings have transferred our executive rights based on the concept of Khilafah to the ruler, we have a right of accountability. Even though the rulers will account to God in the hereafter, they have a right to account to us here first, because we transferred our rights to them. We have a right to ask them to account to us. So I think, the concept of social contract, we don't talk about it much from an Islamic point of view, but I think it has, if we look at it from the concept of Khilafah, Amana, it has a very strong possibility of putting the leadership to account. And this is what human rights is all about. So I don't know what you think about this, whether it falls within your framework, in relation to your replies.
Thank you. We may get one last question, if there is any. Dr. Mutaz, and then we will ask the speakers to conclude with the remarks, and we will end. Yes,
thank you for your presentations. I will just add more example for the human dignity and how it is immersed in the social and local cultures sometimes. So, for example, in the Western culture, prostitution does not transgress human dignity, while in the Islamic culture it transgress human dignity. Now, homosexuality in the Islamic culture transgress human dignity, but in the other side it is human rights now, and then there's a lobbying in the direction of supporting the rights of LGBTs, for example. So we disagree in this regard. How do you identify human dignity? So on the other side, just as an interaction with what Dr. Zara said. So my understanding is that the International Declaration of Human Rights is a product of the international system and the modern nation state. So what the International Declaration, the Declaration of International Human Rights, is trying here to fix problems that the international system produced. For example, just to give a very clear and direct example here. So one of the articles, not necessarily the key, in the Declaration of International Human Rights is that the freedom of movement. So this is a problem that was created by the modern nation state. In the pre-modern nation state, this was not an issue at all. You know, it's ridiculous to show that this is a great production of the Declaration of Human Rights. You know, so because if you go through the bibliographies in the Islamic civilization, so you will rarely find a single scholar that he just stayed in his homeland, you know. So this was something very basic, you know. So the Declaration of International Human Rights is is based on two wings: the liberal philosophy, which is supported by the political powers. And on the other side is that the modern nation state and the what's so-called international society, which is much politicized. Even, you know, look what happened. You know, they didn't achieve anything for the Syrian people who have been killing for more than 1 decade, for example. And at the same time, you know, it seems supporting the LGBT's rights is more important than, you know, considering the rights of Syrians who were killed. And still, Bashar al-Assad is the legitimate president of Syria within the international system. Okay, thank you.
Thank you very much, Dr. Zara. If you can sum it up in 3 minutes, it will be great.
Jazakallah khair for the questions. So the first question was asking about how human dignity as a concept has been challenged by environmental ethicists and in bioethics. And I think your question is asking if in international relations or in the political theory undergirding human rights discourse, if some similar challenges have been made. I have not come across challenges to the concept of human dignity. It seems to me, but you already know that I'm very ideological and can only see things in one way, but it seems to me that there is a desire by secular civilization in any part of the world to hold on to that which is transcendent. And the idea of human dignity is very transcendent. Western civilization is not able to identify what is, the location of where it's transcending to. We can't say that there's a heaven and the soul is eternal. We can't say things like that definitively, but I think that dignity is one of the concepts that is essential. I don't, one of my mentors, the late Professor Yong-Kun Kim, he said that you can't have human rights without God. That God has to be the location, for lack of a better word, within which human qua human rights can have any meaning. If it's just human qua human, there's no real ground, right? And now moral relativism is the absolute victor when it comes to the kind of the normative idea about what our moral philosophy is, but how can you root it? So that's a very long answer to your question, but I haven't come across it. But human rights is not my principal area of research. So if there are detractors out there speaking against the concept of dignity, I have not come across them. Maybe some of our other presenters today would know better. I do have an esteemed colleague in California, originally from the UK, Sidi Ramis Kent, and he put a paper about he's a permaculturist. He teaches permaculture courses to various institutions and universities all over the world. And he wrote a beautiful paper about rooting it in the human dignity that Allah gave to Adam and to all of the progeny of Adam as khulafa upon the earth, but khulafa not understood only in a political sense. So khulafa in the environmental, like the stewardship of the earth, being rooted in our dignity. So that's an example of taking that concept of dignity and perhaps appropriating it through our understanding of some of the Islamic concepts of dignity around the human. Interestingly enough, John Locke did actually say, is this brother's name? Brother, you were asking about the human dignity, about the khulafa, right? The concept of khulafa. John Locke actually did explicitly say that God did not give to Adam a trusteeship and a lordship, not even over his own wife and children, but let alone to be the ruler of the world. So if God didn't give that to Adam, there's no way that the children of Adam can now make any kind of hereditary claim on the same thing. Again, just another example of a foundational principle, maybe not something we all think about when we talk about human rights, but nonetheless it's there within the archives of kind of the founding pillars of what constitutes the notion of sovereignty, right? What is the legitimation of the sovereign state? Locke did think that absolutism should be tempered by a parliamentary system, and he had a much warmer and friendlier vision of the monarch than a Hobbes did. And a much better vision of human nature, right? We weren't all like greedy and war-driven and avaricious. But nonetheless, he did make this remark about Adam alayhi salam and the human inheritance from the first human being. The state of nature, it's actually been something that I think for the last 6 years I really wanted to work on. We have this treatise Hayy ibn Yaqzan by Ibn Tufayl, which is a completely alternative vision to the origins of human beings in society than Leviathan and two treatises on government and Jean-Jacques Rousseau. And it would be really interesting for me to kind of take out the time if I was able to do that kind of a comparison, because the state of nature is not meant as a literal device. It's meant as a metaphor. It's meant as a heuristic device, right? It's just meant to elaborate and explain the justifications for political society. But some of the things that are said about the human being in the state of nature, I don't think are fully acceptable given what I believe about human beings. Are they essentially good or essentially bad, right? Or even someone who is appointed as a khulafa upon the earth, not in the political sense, but just as a moral actor upon the earth, completely distinct from animals and other forms of life. Does that person fit the description of what we get from the state of nature and the reasons? Really, the only reason we go into civilized society is to protect our property, which is a very spiritually empty understanding of the higher purposes. We think of Al-Ghazali saying that political society is one of the essential crafts, right, along with growing food and textiles. Because it ensures happiness in this world and the next, right? And all of the institution building. So I don't think I answered any question yet. Yeah, I don't know. Yeah. Sherman, I'll just leave it with this one last thought, because I think there was a question about human dignity in prostitution, but not necessarily in LGBTQ performance or identity. And also, of course, in Islam, we don't have homosexual as a stable category of identity. The jurists only identified acts which were forbidden and acts which were permissible, and only forbidden acts were punishable. So it was possible for a person to be gay, but to not be punishable because they did not engage in illicit sexual activity, which is very different from kind of a postmodern idea of identity where you are something and that's the only thing you can be. But even prostitution, now we have this discourse on sex work as a human right, like, the protection, basically all of the work of protections that should be going. So it seems like Dr. Sherman Jackson's contribution, he said that we can consider rights as a two-tier system. So for him, human dignity was not like freedom from murder, freedom from rape, and freedom from torture were like top tier protections of human dignity. And then underneath that, and he's saying this as an African American scholar in the United States, he's saying even freedom from racism and freedom from sexism don't count at the same level. So if it's, because sometimes the norms can become hegemonic when there's a cultural lack of translation there. So if we consider the rights on a two-tier system, it might be possible to open up some space in that regard. That's the answer.
Please, Doctor.
Despite what I said a moment ago, I did have a thought on the question of the centrality of human dignity being problematic for environmental ethics. I'm just wondering if it might be possible to depart from different starting points but come to common ground in the environmental principle of intergenerational solidarity. So the idea that, and again, not necessarily something I believe, I'm just trying to reconcile 2 points of view. The idea that human dignity could remain central, but part of that is the dignity of the generations to come who deserve to have a world to live in, essentially. The other point that came to mind is a bit political. It's on the question of LGBT rights apparently being valued less than many, many Syrian lives. I was working on the European side during the main 2015-16 European restructuring of their systems to try to deal with at least providing some kind of a relief to the Syrian refugees, and it was quite the problem you flagged is quite visible. Let's put it that way. The explanation that I heard in the policy discourse was that Europe needed to maintain its own protection space where rights such as LGBT wasn't specifically mentioned, but a high level of human rights had to be maintained in Europe, and in order to protect that protection space, the system couldn't help that many people coming to ask for help at once. It's not a position that I agreed with at the time, and I still don't agree with it, but it is the justification that was put forth.
Thank you very much. Is it something urgent? Yeah.
No, it just, do we have time for an observation to make?
Yes, please.
Okay.
If you can end like 2 minutes or so, because we have it already over time.
Okay, yeah, just a quick observation. To Paul, this is just an example. When you said the Prophet Muhammad went to Medina, and if there was a state, they would have said to you, you are religion. He concluded a number of pacts with neighboring Jewish people, and to say, look, that's your religion to you, no compulsion. And then when the Ghazwat, the war started, there were several other agreements, and people came back. The question of general the dignity, when UDHR was drafted, it was there was no consensus really on the question of dignity. If you look at the preamble, 5 times it's mentioned there, but no consensus. But I think if you look at the preparatory history, there is some sort of consensus to say, look, let's agree on the basic understanding that every human being have equal worth, moral worth inherent in them, and that was kind of the basic understanding just on the question of dignity. Main point about the foundationless
theory, the point you made, I didn't follow which way you were going, but I thought even if it's based on rationality, then rationality is the foundation of. It's not to go against you or criticize. I'm just making an observation, and they say, yeah. When people come to say, it's denuded and it's foundationless. Everything got a foundation. It's like people used to come and tell us when we were talking about freedom of religion. They say, "Oh, we don't believe on anything. I have no religion," and I thought it's nonsense. We all believe on something. It's just you don't believe on God. That doesn't mean you don't believe on everything. So there is a belief system. Atheism, non-theism, that's a system as well. So people come, we all believe on something, and there is a foundation for all these things. Rationality can be foundation. Let's say religion is not. Islam, Christianity, Buddhism, Hinduism, that is not. The moral precepts or ethics from them is not, but rationality is. So it's always this thing. In the literature, people are telling us anything that's not religious, say, okay, somehow it's based on rationality, and that's without foundation, and it's somehow good. But I believe personally there is a foundation, even if it's just rationality. I'm not saying it's right or wrong. What I'm saying is people tell us, I don't believe on anything, but we believe on something. Then they say this is foundationless, but this is. I had discussion with the UN colleague. I'm just finishing up. We were saying, Islamic law is problematic. We were in Italy, this Sharia and military operation, and this UN young guy from Malaysia came and he said, look, there'll be no issues if you just go and have civil system just for everyone. And I say, why? He said, just uniform civil system. I say, well, basically what you think is everybody believes on a uniform civil system. A lot of people want to be governed, let's say, by Islamic law or Christian law.
I believe you have one more day to continue.
Thank you.
Inshallah.
Thank
Let's
you.
stop here. Thank you very much for all your contribution. Thanks to all the speakers.
Yeah. Yeah, let's go take these with us. Okay.